May I please?
Yes.
My lords, I beg to mention item number 26, my lords.
Yes.
My lords, Mr. Progast is unwell, my lords. Certainly you are still unwell. So let the matter come in next week.
We had fixed this matter today.
Yes, my
Okay,
lord.
he's unwell. Okay.
I have taken consent. I
Okay.
have taken consent.
It is submitted by Sri H. A. Sarkar, that Sri A. K. Purkasta, the leading counsel for the petitioner, is unwell, and accordingly he has prayed for an adjournment. Full stop para. List after 2 weeks for hearing, for admission hearing.
Okay.
Like, please,
Yes.
item number 17,
Yes.
that may be directed to be listed in some other bench. Yes.
Okay. 17. Let's before any other bench without me.
Obliged.
My pleasure, Lordship. Lordship, kindly, I have listing for mention, my lord. Kindly, Monday or 6 or 8, my lord. if possible.
Which matter?
Ongonbadi, my lord. Promotion.
No, this is the second bench. Not
Third
here.
bench, third.
This is the second bench tree. Not here.
May please, Lordship. Lordship, I beg to mention item number 11 of
Yes.
today's daily list. Lordship, the arguing counsel, Ms. K. Bora, is having some personal difficulties today. Can be taken up on a short date. If possible.
For the health department.
This would be NHM department.
And
but-
who's unwell?
No, not unwell, Lordship. There is some personal difficulties. A. Bora, on the Bora.
Okay, okay. I have taken the consent.
Yes,
Yes.
Lordship, we have taken.
Okay.
Lordship, kindly fix the matter on 9th May.
We'll fix it. It is submitted. That's MSA Bora, the understanding council NHM, is having some personal difficulties today, and accordingly an adjournment has been sought for. Full stop para. As agreed to by the parties, matter is adjourned to be listed on
9 May.
9th of May. Is it okay
Good.
for you?
Yes, sir.
9/5.
Much obliged.
Yes, Mr. Pata?
My lord, in respect of item number 6,
Yes.
I, my lord, beg to pray that we need to file an additional affidavit, my lord. There have been some subsequent developments. I have accordingly informed Mr. Gupta, the CJC. My lord, would be pleased to
20
grant
matter.
2 weeks time, my lord.
20 matter.
My lord, some additional affidavit
You
is
should have
required.
filed it earlier. We
Hello,
are
we
in
have filed.
2024. After 4 years, does it look good, Mr. Pata?
I understand, my lord, but then there are some orders that have been passed by Meghalaya High Court and implemented, and
You have
some
said
orders
this
from
before. On the last occasion, you had said this.
my lord,
The Meghalaya High Court's order. Okay.
my lord.
Sri B. Pathak, learned counsel for the petitioner, prays for some time to file an additional affidavit. Full stop. List after 2 weeks.
Keep here.
Mr. Gayan for whom?
My lord, I have actually mentioned for item number 13, my lord.
Oh, a separate mention.
Yes,
Okay.
my lord.
Yes.
I will inform Mr. Gupta, my
Okay.
lord, in my time.
13. Yes. What is your prayer?
Keep here.
My lord, we were required to file our affidavit in reply to the affidavit in opposition filed by the respondent number 3 and 4, my lord.
Okay.
2 weeks time may be given, my
Inform the other side.
my lord.
Here we have to inform.
Government, my lord.
Okay. But who is Mr. D.K. Roy? D.K. Roy, I think, is for Seba. Have you informed Seba?
No.
Inform him, we'll adjourn, but without information, please inform him. Make it a habit, and it's a part of the, it's a requirement. You have to inform, consent, then make a mention. We
Much
have
obliged.
taken a note, but we're not passing any orders. Take his consent, can come back.
May
Yes,
please, Lordship,
madam.
I beg to mention item 5.
Fine.
My senior R. Majumdar is out of station. I pray for adjournment for the day, my lord. He'll be back by this evening.
Okay. 18 matter. Yes, Mr. Roy?
Lordship.
It is submitted. That's Sri R. Mazumdar, learned counsel for the petitioner. He is out of station. And therefore, a prayer for adjournment has been sought for. Full stop para. Para. Matter is accordingly adjourned to be listed on today's.
Can it be first week of June, Lord? Because from 10th I will be out of station, Lord. For some
No, we'll have
purpose.
it next on 8th. 8th. It's a old matter.
Lordship.
8th May.
Obliged.
8/5. Yes,
This is the
Mr. Hendrik for whom? PNRD.
PNRD. Third occasion, my lord, there's been no appearance.
Okay. None appears for the petitioner on call, whereas three CS Hazarika Learned State Council as well as three P Hendrik Learned Council representing the Panchayat and Rural Development Department are present. Full stop. There has been continuous non-appearance on behalf of the petitioner. And on the last date, that is 30/4/2024, the following order was passed. Full stop. Para. In view of the aforesaid situation, comma, this court has no other alternative but to dismiss this writ petition for want of prosecution. Full stop. Para. Dismissed accordingly for want of prosecution.
Right, Leader.
Yes.
Or the petitioner was subjected to a departmental proceeding and thereafter, my lord, the penalty of withholding of 3 increment with cumulative effect was imposed. My lord,
Just a minute, please.
my lord.
What's for the other side?
Yes.
Revenue Department.
There
There was a DP against you.
was a DP against me.
3 increments.
3 increments with cumulative.
With cumulative effect.
With cumulative effect.
Okay. Which date?
My lord, the order is 12th November 2013.
12/11.
12/11/2013.
Page.
Page 39.
Okay. Then what happened?
No, look. My lord, the page 19 is the so-called notice. My lord, may I just take your look?
This is the challenge.
This is the
This
challenge.
is subject matter of challenge.
Subject matter of it. The penalty is
Okay. Okay.
my lord will find the page 19, the so-called notice. My lord.
You have challenged, you have structured your challenge on what? Procedural impropriety, irregularity, or on merits? What?
My lord, the findings of the inquiry report is based on conjectures and surmises. There is no evidence. My lord.
You are going on merits.
My lord, first. Second, my lord, the presenting officer, the inquiry officer was itself a presenting officer. My lord. There was no presenting officer. Inquiry officer assumed the role of a presenting officer in the inquiry proceeding.
Well, let us see the rules.
My lord.
What service rules? What is the requirement of the 1964
Well,
rules? You are governed by 64 rules.
64 rule. Rule 9, my lord.
Yes.
Sub-rule 5.
Hmm.
The disciplinary authority may nominate any person to present the case in support of the charges before the authority, inquiring into the charges hereinafter referred to the inquiry authority. The government servant may present his case with this assistance of any other government servant approved by the disciplinary, but may not engage a legal practitioner for the purpose below this.
Hmm.
So, Rule 4 says, well, there has to be an inquiry officer appointed and a presenting officer. Though, my lord, by way of a notification they have issued,
No,
they have
government servant.
the disciplinary authority, well, Rule 5.
Yes.
The disciplinary authority may nominate any person to present the case in support of the charges before the authority inquiring into the charges, hereinafter referred to as the inquiring authority.
May nominate any person to present the case in support of the before the authority inquiring. Who is the authority who will inquire into the charges?
My lord, the inquiry officer was a joint secretary.
No, who is the authority who would inquire into the charges in the rules?
Rules does not specify so, my lord. Anybody can be appointed as an inquiry officer.
Where is the?
Rule 9, sub-rule 4.
Hmm.
On receipt of written statement of defense, or if no such statement is received within the time specified, the disciplinary authority may itself inquire into such of the charges are not admitted, or if it considers it necessary to do so, appoint for the purpose of board of inquiry or an inquiry officer. Either the disciplinary authority itself or may appoint anybody as a board of inquiry or an inquiry officer. So the inquiry officer would be a different, and a presenting officer who would present the charges would be different.
Okay, now what has happened here?
Though by way of a notification, my lord, in the affidavit they have annexed that an inquiry officer was appointed as a presenting officer was also appointed. But no, there was no presenting officer in the inquiry proceeding. It was, in fact, from the inquiry report itself, it is clear. It is only the inquiry officer who has taken as a personal hearing of the petitioner and the witnesses that has been listed as two witnesses were listed. One witness is examined and he said that I have nothing to say about the case. And the other witness said, I refuse to give any statement. And if your lordship will kindly appreciate page 19, what is the allegation, madam?
Page
Page 19 is the so-called notice.
19.
19. There is one charge. Lordship found page 19.
Yes.
You are hereby asked to so cause under Rule 9 of the Assam Disciplinary Appeal Rules 1964, read with section under Article 311 of the Constitution of India, as to why any penalties prescribed in Rule 7 of the aforesaid rule should not be inflicted on you on the following charges based on the statement of allegation attached herewith. That while you were serving as a sub-registrar, you have allegedly registered the following land sale deeds involving quantum of land measuring 7 biga, 1 katha 10 lechas belong to so and so, the sale deed number, as per approved zonal valuation table issued by 5/12/2003, the village Silpukuri falls under the special category 2 zone with the value of ₹5 per lakh per katha. The location of the scheduled land stands very much within 1 kilometer radius of the Silpukuri tank, by which place is repeatedly named hereafter. The difference rate of undervaluation stand at 4 lakhs per katha, resulting in the loss of revenue. As per section 27A, Indian Stamp Assam Amendment Act 2004, you should have referred the aforesaid land sale deed to the Deputy Commissioner after registering these land sale deeds for taking necessary follow-up action by the Deputy Commissioner as per proviso of section 27A of the aforesaid Act. But you have not followed the provision of the aforesaid Stamp Act. Thus, you have not only violated the provisions of section 27A1 of the Stamp Act, but your such inaction has left the Deputy Commissioner Kamrup Metro with no scope to initiate necessary steps for realization of this stamp duty as admissible by exercising his powers conferred under the section 27A2 of the Indian Stamp Assam Act 2004. Due to inaction, the scope of realization of further amount of stamp duty of rupees so and so and registration amount of rupees so and so was kept inactive. You are charged for violation of section 27(1)(a) A1 of the Indian Stamp Assam Act 2004. So basically, the allegation is that because the petitioner did not inform the Deputy Commissioner on time as per section 27(1)(2), and therefore there is a loss of the loss suffered by the government. So it's a violation of section 27(1)(2). And the document, my lord, which they have referred as the as per government approval zonal valuation, that is That, my lord, will find at page 28,
2-8.
2A. My lord will find this is a communication between the commissioner and secretary to the government of Assam revenue department to the deputy commissioner Kamrup Metro. And my lord will kindly turn to the first 27 page 27. Well, I'm sorry, my lord. 28 should have been the first page and 27 should have been the second page.
Yes.
Now, my lord will find the down below, my lord, whom it has been marked, my lord.
Hmm.
The Commissioner Division, the Director of Land Records, Assam Rupnagar, the Director of Land Acquisition and Reforms, Assam Rupnagar, all officers of the Revenue Department, PS2 so and so, Minister Revenue, PS2 Chief Secretary, Assam Dispute. My lord, the petitioner is a officer who falls under the Revenue Registration Department, my lord. This, my lord, the defense which the petitioner has taken in the written statement is that he did not know about this this communication, and it was never been served upon his office. That is the specific plea, my lord. Because 27A, my lord. Now, may I just take your lordship to 27A, my lord, what it says, my lord.
Where you stated you are not aware,
My lord.
you are not served?
Yes, my lord. Page 22 is my written statement.
No, in the repetition.
My lord, yes, in the reply to so cause also I have said,
In the repetition.
in the repetition also. My lord, para 10, page 9. Though it has been said as notification, my lord, it's not a notification. My lord. And even in the so-called reply also, page 24, my lord, I've taken a categorical plea about this, my lord, in 2 paragraphs.
Where?
My written statement to the so-called notice starts from page 22.
22.
Paragraph 3 and paragraph 4, my lord. May I read it? Page 24, paragraph 3. That however, LS commission on the part of the delinquent was neither deliberate nor motivated, but brought about the circumstances beyond his comprehension. That the omission being a bona fide one may be pleased to be condoned
You are
considering this.
reading which paragraph?
My lord, page 24, para 3, my lord. Internal page 3 of the written statement, my lord.
Yes.
That however, the alleged omission on the part of the delinquent was neither deliberate nor motivated, but brought about circumstances beyond his comprehension. Therefore, the omission being a bona fide one may be pleased be condoned, considering the same as a human error, inasmuch as no government circular fixing the valuation of the land as referred in the so-called letter was ever received by this office. That the government circular issued by so-and-so referred to in the so-called was a mere inter-office communication addressed to the deputy commissioner and the settlement officer resettlement operation with the copies to the commissioner division so-and-so so-and-so. As such, the answering delinquent did not have knowledge of the same. Hence, on principle alone, no liability should be attributed to the delinquent who were unaware of the said government direction. Had there been a formal gazette notification in lieu of the said office order, the registering officer as well as the revenue officers allowing mutation on the basis of such deed would have been able to refuse registration of documents as well as mutation graded based thereon.
Yes.
This section 27 of the Indian Stamp Act, my lord. Before I come to the offending clause here, my lord, where allegation has been leveled that I have violated section 27(1)(a), that is of Assam Amendment. My lord will take up 27 of the Central Act, my lord. Indian Stamp Act 1899.
Yes.
Facts affecting duty to be set forth in the instrument. The considering, if any, and all other facts and circumstances affecting the chargeability of any instrument with duty or amount of the duty with which it is chargeable shall be fully and truly set forth therein. So, my lord, the obligation is upon the parties of that conveyance, my lord. They, whatever they state in that, it is to be constituted that it is correct. And the Indian Stamp Act nowhere empowers the registering authority to make an independent inquiry with regard to the valuation. My lord. Now, may I take your lordship to section 27A, my lord, of the Assam Amendment? My lord is holding this book.
Amendment of which year?
2004, my lord. Page 118, possibly, my lord. If your lordship is holding.
Yes.
May I read 27A, my lord?
Yes.
Instrument of conveyance, etc., undervalued, how to deal with. If the registering officer appointed under the Registration Act while registering any instrument of conveyance, exchange, or gift, my lord will note this, has a reason to believe that the market value of the property as fixed by the government collector of the district, which is subject matter of the conveyance, exchange, or gift, had not been truly set forth in the instrument, he may, after registering such instrument, refer the same to the collector for determining the market value of such proper and property duly payable thereon. On receipt of a reference under subsection 1, the collector shall, after giving parties a reasonable opportunity of being heard, and after holding an inquiry in such manner as may be prescribed by the rules made under this Act, determine the market value of the property which is the subject matter of the conveyance, exchange, or gift, and the duty as aforesaid, and thereupon the difference, if any, the amount of duty shall be payable by the person liable to pay the duty. Roman 3, Sub-Rule 3, the collector may on its own or otherwise within 2 years from the date of registration of any instrument or conveyance, exchange, or gift not already referred to him under subsection 1, call for and examine the instrument for the purpose of satisfying himself as to the correctness of the market value as set forth in such instrument, which is the subject matter of conveyance, exchange, or gift, and the duty payable thereon. And if such examination he has reason to believe that market value of such property has not been truly set forth in the instrument, he may determine the market value of such property and the duty as aforesaid, and thereupon the difference, if any, in the amount of duty shall be payable by the person liable to pay the duty. My lord, here the role of the registering authority is only if he doubts that the market value is not correctly set forth as it is required under section 27, then he has to refer it to the deputy commissioner. 3, my lord, makes it very clear, my lord, the deputy commissioner on its own also can cause an inquiry. When it came to the notice of the deputy commissioner, my lord, nothing prevented the deputy commissioner to cause an inquiry to recover the loss. Therefore, my lord, the loss that has been suffered, my lord, cannot be attributed upon the petitioner in my respectful submission. Because the petitioner never had no reason to doubt that the amount that has been set forth in the sale deeds, my lord, are below the market value that is fixed by the government. Now, my lord, we'll kindly take up Registration Act for a moment. Because the registering authority, and as per section 34, section 32, my lord, cannot refuse registration if the prescription of section 32 is fulfilled, my lord.
Which registration act? which-
Registration Act, section 32, my lord.
Please read.
Hello. Persons to present documents for registration, except in cases mentioned in section 31, 88, and 89. Every document to be registered under this act, whether such registration be compulsory or optional, shall be presented at the proper registration office by some person executing or claiming under the same, or in case of a copy of the decree or order claiming under the decree or order, or by representative or assigned such a person, by agent of such a person, representative or assigned, duly authorized by the power of attorney, executed and authenticated manner hereinafter mentioned. If this is done, my lord, if this persons appear before the register authority, then register has to register it. And the power of inquiry that is,
No,
Come.
the second part has to register. Where is it?
my lord,
This is.
my lord, the first line itself, every document to be registered under this act,
Yes.
whether such registration be
No, this is-
compulsory or optional, shall be presented at the
This
proper
is with regard to who would present the documents.
present. Once it is presented before the
But thereafter,
registrar,
what has happened? What is the compulsion or what is the mandate of the?
the mandate, my lord, is that if it is placed at the proper registration office
Hmm.
by some person executing or claiming under the same,
Hmm.
in case of a copy or decree or order claiming under the decree or order,
Hmm.
by representative or assign of such
That we have
person,
read.
my lord,
Hmm.
an agent of such person.
Hmm.
Now, my lord, the section 34 confers a power upon the registering authority to inquire.
Hmm. Yes.
Subject to provision contained in this part and in section 41, 43, 45, 69, 75, 77, 88, 89, no document shall be registered under this act unless the person executing such document or their representative assigns or assigned agents authorized as aforesaid appear before the registering authority officer within the time allowed for presentation under section 23, 24, 25, and 26. Provided that if owing to an urgent necessity or unavoidable accident all such persons do not so appear, the registrar, in case where the delay in appearing does not exceed 4 months, may direct that on payment of a fine not exceeding 10 times the amount of the proper registration fee in addition to the fine, if any payable under section 25, the document may be registered. An appearance under section 1 may be simultaneous or a different time. Now, my lord, subsection 3, my lord. The registrant officer shall thereupon inquire whether or not such document was executed by the person by whom it purports to have been executed, satisfy himself as to the identity of the persons appearing before him and alleging that they have executed the document. If in the case of any person appearing as a representative, assigned, or as an agent, satisfy himself of the right of such person so to appear, any application for a direction under proviso to subsection 1 may be lodged with his register who shall forward it to the register to whom he is subordinate. So, my lord, the power of inquiry that is conferred upon the registering authority is to, with regard to the persons who have come before him, not with regard to the valuation or the chargeability. Because once section 27 says, in fact, section 64 of the Indian Stamp Act, if I may so, my lord, the consequence of violation of section 27. Section 64 of the Indian Stamp Act 1899, my lord, page 53. Merit.
Yes.
Penalty for omission to comply with provisions of section 27. Any person who with intent to defraud the government executes any instrument in which all the facts and circumstances required by section 27 to be set forth in such instrument are not fully and truly set forth, or being employed or concerned in or about the preparation of any instrument, neglects or omits fully and truly set forth therein all such facts and circumstances, or does any other act calculated to deprive the government of any duty or penalty under this act,
Yes.
shall be punishable with fine which may extend to 5,000 rupees. So, my lord, the consequences is always upon the, my lord, the persons who are the parties to the conveyance.
Yes.
Now, may I just take your lordship to the inquiry report, my lord?
Yes.
Before that, my lord, page 30 for a moment.
30.
30.
Yes.
It's a communication from the district registrar to the Guwahati resettlement officer, my lord. But I intend to show the first paragraph, my lord. With reference to your letter cited above, I have the honor to inform you that the registering officers are not empowered to inquire whether the immovable property mentioned in the sale transfer deed are properly valued or not. There is no such provision in the Indian Registration Act under which the registering officer are appointed. This is the position of law, my lord, which in fact the Supreme Court has also held that the registering authority, my lord, cannot inquire into the value that is set forth in the conveyance. And this position of law para 10 of this judgment. My lord, find para 10.
Para?
Para 10, my lord.
Yes, please.
It was urged that in view of section 27 of the Stamp Act, it was permissible for the revenue to look into the terms and condition of the agreement entered into by Uttam Chand with various persons to whom he had assigned flats, offices, shops, particularly in view of the fact that the impounded document makes reference to those agreements. We are not able to accept that contention. Section 27 prescribes that the consideration, if any, or any other facts and circumstances affecting the chargeability of any instrument with duty or the amount of the duty with which it is chargeable shall be fully and truly set forth therein. It is true, in view of this provision, the parties to a document are required to set forth in the document fully and truly the consideration, if any, and all other facts and circumstances affecting the chargeability of the document with the duty or the amount of duty with which it is chargeable. But a failure to comply with the requirement of that section is merely punishable under section 64 of the Stamp Act. No provision in the Stamp Act empowers the revenue to make an independent inquiry of the value of the property conveyed for determining the duty chargeable. Article 23 is the article that governs that the charging of the stamp duty on conveyance. That article, to the extent relevant for our present purpose, read as so and so. So basically, my lord, the registering authority, my lord, unless he has a reason to believe, unless he doubts it, my lord, he has no power to inquire, my lord. Whatever is set forth in the document, he accepts it is as true. It is a bona fide disclosure by the party. Now, my lord, with regard to the communication, which is the basis for attributing the default and negligence on my part, my lord, would kindly take the inquiry report at page 32, my lord. I'll start with third paragraph, my lord.
Hmm.
The first two paragraphs of the allegation.
Yes.
Statement of charged officer so and so and the witness so and so were recorded on 20/01/2010 and 25/02/2010 respectively. The other witness, Bipin Goswami so and though was present on 21/2010, refused to make any statement. The Goswami agreed to have registered alleged sale deed during March 2007. Now, my lord, would kindly mark this date, my lord. And lordship will note the so-called notice date, my lord. It is 10 September 2008. Meaning there, my lord, it is within 2 years. So the deputy commissioner, upon knowing about this, my lord, he had an option of causing an inquiry to recover the loss, my lord.
No, this power to be exercised by the deputy commissioner, will it absolve you from all the liabilities?
No, it will not.
Why are
because-
you emphasizing on the role of the deputy commissioner?
No, my lord, why I am saying
You
so?
present your case.
No, why I
If
am
the deputy commissioner has failed in his duty, the appropriate
Madam-
the department, the authority will take against
my
action.
lord, would kindly appreciate why I am saying
It's not
so.
immune from any.
No. Why
Any
I'm,
action?
my lord, why I'm saying so? Because the allegation is that because I did not inform the deputy commissioner, government has suffered a loss of so and so, etc.
Yes. We are
Therefore,
on
my lord-
that.
my lord,
We are
yes.
on that.
My lord.
What is your explanation? The deputy commissioner could have on his own motor, so I have not informed.
No.
So
I-
if that is not your
Not
if that is not your explanation, stick to your explanation.
Yes, my explanation is
Don't
that
don't go to the part of the deputy commissioner.
No,
What he should have done, he has not done. We are not bothered.
No, of
Neither
course.
we are examining
But-
that issue.
my lord, why I'm trying to
Yes, please,
uh,
please.
the the Goswami agreed to have registered at the LA sale deed during March 2010 at a value in the sale deed by the sellers and purchasers. But stated that he was not aware of the government circular dated so and so fixing the land value for the purpose of sale purchase Guwahati, and therefore they registered the deeds only after ascertaining the value of stamp fixed on the deeds as per the value of the transaction. In short, he have agreed the registered of the deeds at a lower value due to his ignorance about the government circular fixing the land value for the purpose. Sri Pavitra Kumar Das LDA, who is listed as one of the witness by the department in his statement, denied having any knowledge about the subject as his work allocation involves mainly furnishing of papers relating to court cases and submission of list of registered deeds to the IGR Assam after their entry in the relevant volume. Therefore, his statement is of not of very essential in this case. From the above, it is clear that the charge official Sri Goswami executed 15 numbers of land sale deeds shown in this statement of allegation while he was serving as a sub-registrar Guwahati. It is also seen that the deeds were registered by him at a lower value than the valuation fixed by the government so-and-so dated 5/12/2003. As a responsible officer, he is expected to have knowledge of the relevant acts, rules, and other government instruction issued through circulars by the concerned department for smooth functioning of the duties and responsibilities entrusted on the responsible officer. So, my lord, this is neither it is an act, neither it is a notification, nor it is a circular, my lord. It was a communication between the two authorities, my lord. And the copy was also not marked to the office of the sub-registrar or the revenue registration department. Had it been, my lord, not a sub-registrar, but it had been communicated to the revenue registration department, then the sub-registrar of the all district would have come to know. Considering all the above, the charges level against Raj Subham Goswami, the then sub-registrar, is proved beyond any doubt. So, my lord has also observed that this document, whether it was served upon the, my specific plea was that it was never been served upon the office, and I did not have knowledge about this document. So it is nowhere proved by in the inquiry that it was served and I had the knowledge. Now, page 39 is the order of impugn order, मतलब imposing penalty.
39.
Page 39. Merit.
Please.
After careful examination of all relevant documents, records pertaining to the instant departmental proceeding against so and so, the then sub-register, now sub-register Amin Gao, drawn up by later dated so and so, in considering all aspects of the instant case, it is seen that the aforesaid departmental proceeding, there was only one charge framed against the aforesaid officer. The charge was that while aforesaid officer was serving as a sub-register under the district register Kamrup Metro, he had allegedly registered 15 numbers of sale deed so and so, so and so, so and so, involving land measuring 7 bighas, 1 kathas, 10 lechas, belong to Sohor Part 2 under Ulubari Mouza in the Kamrup Metro district as lesser value than fixed by the government for purchase and sale, situated in so and so in Guwahati, Wide, later dated 5/12/2003, and thereby incurred loss of government revenue amounting rupees so and so. He has failed to refer the matter to the district register as provided under proviso 27A1 of the Indian Stamp Act Assam Amendment 2004, and thereby left no scope for district register to take necessary action for realization of the stamp duty and the registration fee. On perusal of the inquiry report of the inquiry officer appointed by so and so, it appears that the matter of allegation under charge 1 of the instant case has been elaborately discussed by the inquiry officer based on submission by the charge officer in his written statement and oral statement made before the inquiry officer. It reveals that the inquiry report that the charge officer could not produce any evidence, documentary proof that he was not guilty in any way. So, malab, the burden was shifted upon the delinquent to prove the charges. No?
To disprove the charges.
To disprove, sorry, to disprove the charge. For registration of the aforesaid land sale deeds made by him in his capacity as sub-register Guwahati in 2007 and causing loss to the state exchequer, as per findings of the inquiry officer, the charge against the officer has been proved beyond doubt. In view of the above, the governor of Assam is pleased to inflict punishment withholding 3 increments which would have been entitled to him after his date of suspension with cumulative effect upon so and so as per prescribed under Rule 7 of the Assam Discipline and Appeal Rules 1964. But I'll rely on one judgment of the Honorable Supreme Court in Root Singh matter. Para 17 of that. Pilot point para 17.
Just a minute, please. One seven.
One second.
Yes.
Furthermore, the order of disciplinary authority as also the appellate authority are not supported by any reasons, as orders passed by them have a civil consequences, appropriate reasons should have been assigned. If the inquiry officer had relied upon the confession made by the appellant, there was no reason as to why the order of the discharge as by the criminal court, so and so on the basis of the same evidence should not have been taken into consideration. The materials brought on record pointing out the guilt are required to be proved. A decision must be arrived at some evidence which is legally admissible. The provisions of Evidence Act may not be applicable in the departmental proceeding, but the principles of natural justice are. As the report of the inquiry officer was based merely on ipse dixit, as also surmises and conjecture, the same could not have been sustained. The inferences drawn by the inquiry officer apparently were not supported by any evidence. Suspicion, as is well known, however high may be, under no circumstances be held to be substituted for a legal proof. Now, this I am relying, my lord, because when I have denied in my defense, my lord, that I had no knowledge about this circular, my lord, and this circular was not been proved.
No, you have read 17.
My lord, 17. Where did it
How
again?
does it start?
My lord, it starts. Furthermore, the order of disciplinary authority, the second last page,
17.
17.
Okay. Yes. Yes, there is another 17 in the earlier page.
I'm sorry, my lord. This is that's 17 is the reiteration, my lord, the quoting of the earlier Supreme Court judgment. May I just read this once more?
Yes, please.
Furthermore, the orders of the disciplinary authority, as also the appellate authority, are not supported by any reasons, as the orders passed by them have severe civil consequences. Appropriate reasons should have been assigned. If the inquiry officer had relied upon the confession made by the appellant, there was no reason as to why the order of discharge passed by the criminal court on the basis of same evidence should not have been taken into consideration. The materials brought on record pointing out the guilt are required to be proved. A decision must be arrived at on some evidence which is legally admissible. The provisions of Evidence Act may not be applicable in a departmental proceeding, but principles of natural justice
Okay,
are.
we have read.
Hello. So if your lordship has seen from the inquiry report, it is basically based on the surmises as to that the government officials should know about the acts and rules and the circular. Whereas, my lord, these documents is a part of the this document is the basis of the allegation, but these documents was nowhere proved, my lord. Merely presenting a documents will not do. It has to be proved, my lord. When I have taken a defense, my lord, in my respectful submission, my lord, when I have taken a defense that this was never been served upon me, it is not within my knowledge. So it has to be proved that it was within my knowledge. And despite that, I have not complied with the mandate of Section 27A. And therefore, there is a negligence on my part.
Okay. Okay.
That's all.
Well, what is the penalty? It's stoppage of 3 increments. Cumulative. You are in service.
I have just retired.
Just retired.
Just retired.
Okay. When did you retire?
30 September month.
Last year.
Last year, 2020.
39.
30/09/2023.
Okay. Yes.
Yes. Okay, this is file an affidavit, okay? File an affidavit.
Here for revenue department.
Revenue department.
Yes.
Page 44. Okay. Start. Page 44. Right. The delight page para 4, 6, 7, 9, 10, 12 and short paragraph. Okay.
Paragraph 4.
4. Okay. That with regard to the statement made in paragraph 6 of the writ petition, it is true that it is not true. Presenting officer was appointed by
notification that so which was informed to the petitioner by memo copy of the same notification. Paragraph 6, with regard to the statement made in paragraph 8 of the petition, it is stated here that under section 27A1 of the Indian Stamp Act, the petitioner might still refer the matter to the concerned district register even after registration of the sale deed. That with regard to the statement made in paragraph 9 of the petition, it is stated that the gazetted, as a gazetted and registering officer, the petitioner should knowledge about the zonal value of the land necessary instruction issued by the government which is in this regard. But paragraph 9, Lordship, with regard to the statement made in paragraph 12 of the petition, it is not true. As per paragraph 27(1)(a) of Indian Stamp Act, if registering officer has any doubt regarding the fixation of market value of land, he may refer the matter to the sub-district register for clarification after registration of deed. Here, the petitioner might refer the matter to the concerned district register after registration of the sale deed. Then, Lordship, para 11. With regard to the statement made in paragraph 14 of the petition, it is not true. Due to negligence of the petitioner, government revenue due to negligence of the petitioner, government revenue amounting of rupees 28,70,350 was lost. Then paragraph 12, that with regard to the statement made in paragraph 15 of the petition, it is stated that as per Assam Service and Disciplinary Rule 1964, the petitioner was informed regarding appointment of inquiry officer and presiding officer by memo number 20. And last paragraph, paragraph 13, with regard to the statement made in paragraph 16 of the petition, it is not true. The list of documents were sent to the petitioner along with so-called notice that is 20. Apart from that, I want to draw your attention to the so-called reply of the petitioner. So-called reply. Page 19.
19.
One line.
Yes.
Sorry. No, supposed to reply. It's 22. It's
22.
22, start from 22. I'm relying 23.
Hmm. Which paragraph?
21A, C, 1A.
Hmm.
May I reading? That both the parties to the deed, seller and purchaser personally appeared before the delinquent, who on the relevant point of time was one of the sub-register posted in the sub-registry Kamrup Guwahati, and satisfied him on the matter of consideration amount public valuation of the land set forth in the deed. The land in question was valued lower than the normal market price, as the lands were shown to exist in very low-lying areas requiring deep earth filling, involving heavy investment, and further, most of the lands were having no direct accessibility to the main road. Considering these two main factors, the price of the land were fixed much lower than the normal market price by the buyer and seller, as deposed by both the parties being personally present before him. Meaning thereby that he knows that there is a zonal value, that he knowingly he has registered the sale deed lower than the normal price. He has given reason. Last line. Considering these two main factors, the petitioner, the price of the land were fixed much lower than the normal market price by the buyer and the seller, as deposed by both the parties being personally present before him. Second, the paragraph C. Delinquent officer, being the registering officer appointed under the Registration Act, have been unable to conduct any independent inquiry under Stamp Act as to ascertain the valuation of the land. Therefore, he had no other reason to refuse the registration of sale deed, which were presented for the registration by the executant, having complied with all requisite formalities laid down in the Registration Act. Then D, Lordship, next paragraph, 24. that registration was allowed on good faith. We have not encouraged that there must be a donal valuation or one notification maybe. That registration was allowed on good faith on the sole testimony of the buyers and sellers who were under an obligation to set forth in their respective list of conveyance a true or correct account or valuation of the properties bought by them as laid down in section 27A. Section 27A lawsuit provides that he should not inquire the matter of this. Section 27A sorry. Done. 27A.
Yes, we have.
If the registering officer appointed under Section 1908 while registering any instrument of conveyance, exchange, or gift has reason to believe that market value of the property as fixed by the government collector of the district, which is subject matter of the conveyance, exchange, or gift, has not been truly set forth in the instrument, he may after registering such instrument refer the same to the collector for determination of the market value of such property duly payable to them. It is his duty to, if there is doubt, then he should refer the matter to the district collector immediately after registering. The petitioner district case is that he has ignorance of law. Firstly. So it is well settled that the ignorance of law has no excuse. Being a responsible officer, he should know the donal value. Otherwise, he is another aspect. If I point out, he's joined in service 1998. Suppose we assume that he has registered till after appointment of that. That may be a human error. But 98 he has appointed and he has done this misdeeds in the year 2007. Ample opportunity was scope was there. Then same best 2, sorry, 24. That it is further submitted that 24, para 2. It is further submitted that there was of course an obligation cast upon delinquent to refer the transfer list after registration to the Deputy Commissioner under Section 27A. However, due to oversight of the same, he admitted this police authority. Due to oversight, the same would not refer to the Deputy Commissioner, though all arrangements were made by him to do so as to enable the Deputy Commissioner to determine the differences of duties, if any, payable thereon on account of undervaluation of the property sold thereunder, which of course amounts to omission on the part of the performing his duty. But still he has admitted all these things. So, then after inquiry report, after submission of inquiry report to the petitioner, they have submitted one representation. Same thing has been reiterated. No new grounds.
Page.
Page 34. Page 34. He has submitted one representation. Same thing, page 35 D 1D, that the registration was allowed on good faith on the sole testimony of the sellers and buyers. He has not entered into the matter, who were under the obligation to set forth in their respective lists of the
35 para
1D, that the registration was allowed on good faith. Being a responsible officer, he should inquire the matter first. Suppose that the registration was allowed on good faith on the full testimony of the sellers and purchasers who were under obligation set forth in their respective deeds of conveyance. A true and correct public valuation of the property sold bought by them was laid down in section 27 and 27A of the Stamp Act. Regarding the procedural alert, no inquiry officer was present, appointed or presenting officer appointed. He has not stated in the representation as well as so-called reply. First time he has asked this to before this honorable court of it. Regarding the evidence part, I want to place one judgment with it.
Citation.
Yes, 1977 2 SCC 491. Set of Harina versus Rokon.
Para?
Relevant para 4. It is well settled that in a domestic inquiry, the strict and sophisticated rules of evidence under Indian Evidence Act may not apply. All materials which are logically probative for a prudent mind are permissible. There is no allergy to hearsay evidence provided it has reasonable nexus and credibility. It is true that departmental authorities and administrative tribunal must be careful in evaluating such material and should not glibly follow what is strictly speaking out relevant under Indian Evidence Act. For this proposition, it is not necessary to cite decision nor textbook, although we have been taken through case law and other authorities by counsel on both sides. The essence of judicial approach is objectively exclusion of extraneous materials and our considerations and observance of rules of natural justice. Of course, fair play is basis and perversity, and if perversity or arbitrariness, bias, or surrender of independence of judgment precede the conclusion risk such finding, even though of a domestic tribunal cannot be held good. However, the court below misdirected themselves, perhaps in insisting that passengers who had come in and gone out should be seized and brought before the tribunal before a valid finding could be recorded. The residuum or rule to which counsel for the respondent referred based upon the certain passengers from American jurisdiction does not go to that extent, nor does the passage from Ellsbury insist on such rigid requirement. The simple point is, was there some evidence or was there no evidence? Not in the sense of technical rules governing regular court proceeding, but in a fair common sense, a way as mean of understanding and worldly wisdom will accept. Viewed in this way, sufficiently of
Mr. Doctor,
evidence.
you have the records?
Plus it.
Records you
Plus
have?
it, plus.
Let us see the records.
Regarding evidence part.
Yes.
One.
देखा.
Assamese part. Page 173. statement of the petitioner. Stop.
See, Mr. Doctor, the charge, no doubt, is a serious charge,
Serious.
causing loss to the government exchequer. But how have you proved the charge?
Sir.
What is the entire objective to have a disciplinary proceeding?
But the petitioner have not denied that they have
No,
We have not-
petitioner has said that he was not aware of a particular communication. It was not served upon him. We may let us assume that his what he's projected is not correct. But somebody has to say that it was in the office,
Lordship.
or I
Regarding
know.
one query was raised, Lordship, earlier also, Lordship.
Yes,
One instruction we have received, Lordship.
yes, what is it?
Yeah.
See, this instructions is of immense relevance, but at what stage? Did you adduce any evidence that this circular which the petitioner is denying was indeed in the office and every officer is bound to know about it? Has anyone said so?
No, no. In the record, there is nothing.
There are two witnesses.
Lordship.
One did not state anything.
Lordship.
One said, I am not aware of the
aware.
on the nature of the allegation.
Look.
His works are of a different in a different aspect. So how have you proved the charge? At least semblance of proof.
Therefore, Lordship, for entire record, there is nothing.
Two witnesses.
So it-
One did not come. One said he is not aware. So where is the element of
so
there being something established that of his misconduct?
Here, Lordship, respondent
You may be
will-
absolutely correct, and in fact, we are also not accepting what Mr. Kaushik is trying to say, that he was not aware.
never.
These are matters of everyday knowledge, everyone is aware,
Look.
but still something has been done. But can you proceed on the assumption that he was aware? After all, he has been charged with a misconduct.
Lordship. As of now.
The penalty comes later.
Look.
He is charged with a misconduct, and you need to prove the misconduct. And the finding of the inquiry officer that he did not adduce any materials or evidence that he is not guilty, that I think that finding is a totally misconception of law and procedure. It is not how you proceed. Unless you discharge your burden, how the onus would shift upon him? The burden is primarily upon you. You discharge your burden, the onus will shift upon the other side. He's not required to say anything. Charge is no doubt
Area.
serious.
That document, the inquiry report, record. That document.
Yes, you are correct in stating that in his reply to the show cause,
Look.
as well as the second show cause,
Second document.
there are certain admission
Look.
that he had done it in good faith.
Look.
But will that be enough to punish him? What role the collector or the district registration officer could have played, that we are not too much
No.
concerned. We are mainly concerned with the role and the obligation cast on the petitioner as a registering authority, registering officer.
Yes. On similar cases, if one person has pleaded is guilty, and thereafter the DP has initiated and DP initiated, the punishment has been imposed.
Here, there is no admission as such. He has said that he acted in good faith,
Right.
and there may be omission, but there's no as such admission of guilt. Okay, we'll consider. We'll think over. Anything, Mr. Kaushik?
My lord, in my respectful submission, my lord, the good faith has to be understood in the context of section 27, my lord. Because
No, see, your defense, we are not too much impressed with your defense. Your good faith, you know, of knowledge, but we are
No,
mainly on the part,
no.
what were the material before the inquiry
Yes.
officer to come to a finding?
my lord, if your lordship, what my learned friend tried to show from page 34, my reply, second reply.
Hmm.
Page 35, my lord, B, C, and D, my lord.
Hmm.
While accepting the registration of the land signet, I did not have any reason to believe. He also reiterated the same thing. I had reason to believe that the valuation of lands were fraudulently undervalued by the executants, as the transfer
No,
is named therein.
that statement of yours is not consistent with the first paragraph. You have come to a finding that these are low-lying lands, and
Yes.
therefore you accept it in spite of knowing that it's
That-
in the heart
Yes,
of.
my lord, but
That
the-
is not
my
consistent.
lord, but the
If it was a case of total no, you are not even aware it's a low-lying or what, you go ahead, good faith. You knew that it was some reasons were being shown that it's low-lying, therefore it's the valuation is less. You apply your mind, you come to a satisfaction. Then coming to the second part may not be consistent. Okay,
Mm.
we'll consider.
otherwise, my lord, this stand of the that this circular was this communication was never been served. It is consistent.
That is difficult to, for us to.
And that is then, my lord, internal
difficult.
communication between the two authorities, my lord.
Internal communication to authority not accepted. It's not something in the file which is not even communicated. It's been communicated.
No, my lord.
And
Yes.
it's not of recent origin. The communication and the registration, there's a time gap. You saying that you are not aware, that is not acceptable.
Because if your lordship will kindly appreciate.
Today you are doing hundreds of registration, you say you are not aware of what evaluation. Is it acceptable? Just tell us.
My lord, this is only in
Is
respect
it
of
you
a
have some place which you don't even know?
and this is a particular area. This valuation is of our particular
It is
area.
under your jurisdiction.
Yes.
You will be the first person to
Well,
know.
True.
You will be the first person to know because you are the person who will be registering.
Well.
And you say that I am not aware of the valuation.
The allegation, my lord, if your lordship will
Going by
kindly.
that technically, it is not
Just
marked
one
to
line
you,
from the
not marked
allegation.
to you, not in your office.
My lord,
That is
just one
difficult.
line from the allegation, my lord, in this so cause, my lord,
Something we have considered.
Hello.
Heard. Sri B. Kaushik.
that within 1
One-
kilometer radius of that area.
Learned counsel for the petitioner. Also heard Sri S. Datta, learned standing counsel, Revenue Department, who has also produced the records. Sri C. S. Hazarika, learned state counsel is present for the official respondents, other official respondents. The hearing is concluded. The judgment is reserved.
Obliged, grateful.
We're returning the records, Mr. Datta. Mr. Doctor, just do one thing. You just identify the pages in the two books to our court master. He'll photocopy it and put it in the records. You know what are 27A of the Assam amendment, then 27 of the original Indian Stamp Act 1809, Registration Act 3234, also 64 of the Indian Stamp Act, 4 sections. Excellent.
May I please, your lordship?
Just a minute, please. Record. Yes,
May I please, your lordship?
yes.
Can we pass over the day, lordship?
Item numbers 15 matter. We're not passing this over.
Lordship, there is a special DB constituted by the registry lordship, court number 2 and court number 5.
Your senior is there. What is the matter, Mr. Sharma?
In this case, we have challenged the appointment procedure. Two posts of junior assistants in the office of District Industry and Commerce Center has been filled up. But
Okay.
in this process, entire selection process has been conducted very illegally.
You are one of the contenders.
I was one of the candidates. So 2 persons selected. Even there is instance that
Madam, for whom? Private respondent. Okay.
Lordship, we have the record.
Okay, we'll go ahead. And for Mr. Kolita's part, we can fix another date. We'll want to complete this 15 matters. Okay? We'll hear Mr. Kolita on maybe tomorrow. Let us see what case is made out.
that might
If at all there is a requirement, we'll definitely hear.
Hello. First of all, I would like to point out, Your Worship, that there was a selection committee to look into the overall selection process.
Selection committee
Selection
for,
to look into the overall process of selection.
okay.
But Worship, you see that selection committee had not worked at all. Everything has been done by the district general manager, District Industry Test Center. Everything he has done. That selection committee has been given complete go-by, and that selection committee.
Everything done by whom? District?
General Manager, District Industries and Trade Center.
District Industries,
And Trade Center.
DI,
He had appointed different selection committees for different purposes. And at last, that selection committee, which was appointed earlier, at last that selection committee said only once for last selection.
okay.
Last selection.
What was
And
the post concerned?
the post was for junior assistant.
How many posts?
2 posts were there.
Advertisement?
Advertisement is there. Advertisement is page number 2.
Okay. Here
P2.
for whom? Respondent number? Private respondent. Okay. And you, for okay, okay. You are the 2 selected candidates. Okay, we'll come. Yes, 3rd of September. What?
3rd of February 2015.
Advertisement.
Advertisement.
Okay.
So, my lord, very interestingly, my lord, when we came to know about the,
What was the procedure adopted?
my lord,
What was the procedure for selection adopted?
procedure for selection, they have initially they have written a procedure by they have appointed one selection committee.
No,
Overall,
no, what is the procedure for selection? Was there any written test?
they had one, I think, one written test. There was one written test,
Yes,
one computer typing test, and
yes,
then Viva.
then yes, Viva was it.
Hmm.
Okay. Three stages.
For all three stages, there were three committees.
Okay.
Three committees were there.
Hmm.
Three committee meetings are shown here.
Hmm.
Three committee meetings are also shown here.
Hmm.
And my lord, first of all, I am showing you that the selection committee meeting, final selection committee meeting, which have given the appointment, that constitutor of final selection committee meeting. This final selection committee meeting consists of 4 members. At page number 57.
57. Yes. Selection committee meeting.
Yes, there are 4 members, including number 4 is S. Gum, head assistant oblique senior assistant.
Hmm.
This person says that he was never member of that committee. In reply to one RTI application filed by the petitioner, he said that I had never been member of any such committee. My lord, page number 61. That is my RTI. In my RTI,
Page?
page 61.
Yes.
In my RTI application step, you will find that he has written by his own handwriting a footnote that he was never a member in established level. That I would like to inform you that I am not a member of the selection committee. My duty is relating to files only. Then he is given separate reply also. Page 63. Page 63. My translation is page 62. Translation page 62. Regarding the above mentioned, I would like to inform you that I am not member of selection committee for selection of post of junior assistant for district industry and trade commerce Golaghat or of any other committee, and I cannot have any comment upon this matter. Further, I inform you that I was not present in Viva as member of selection committee. Further, I inform you that I am performing my duty only as a head assistant and keep government files in my custody in terms of instruction of department. Lord, my lord, he has also been shown to be a member of another committee. He has been shown as member of another committee also. My lord. That is, I got that also. I got in RTI. Haiba committee also he has shown as member.
Yes.
My lord, My lord, firstly, my lord can see page number 20 of my reply. In lecture R24, page 21 of my reply. It is page 20. It is overall selection committee.
Just a minute, please.
Okay.
Page, which page are you referring?
It is page 21, my lord.
21, yes, this is what?
Page 21.
Paper notification,
Page 21 of my reply, my lord.
page 21,
Of my reply.
reply affidavit.
Reply. Page 20 of my 21 of reply. This
Just a minute,
reply against affidavit of respondent fee. Reply against affidavit of respondent fee.
21,
Page 21.
21A, is it 21A or what?
Okay. R4.
Is it 28th of March 2015?
Yes, my
This was running page 108.
yes, my lord.
What is this
It is, my
notification?
lord, in consequence of government letter number dated 2010 for appointment of candidates to vacant posts. The undersigned selection committee hereby constituted with following members: general manager, district employment officer, function manager, head assistant, senior assistant. That is head assistant is Mr. S. Gum, who said that he is not member of any committee.
Okay.
This committee has been constituted the committee after completion of the entire process of appointment as per state rules of the government of Assam
Hmm.
will recommend suitable candidates for appointment in due course. So this was committee after notification,
Hmm.
this committee was constituted. This committee was to look after the entire selection process.
Yes.
This one of the members of this committee said that he had never attended, he was not a member of the committee. And further, my lord, we have received one communication from the another member of the committee, this committee, who says that there had not been any meeting of the committee, this committee, any meeting of the overall selection committee meeting, except the last meeting for appointment of candidate. Except the last meeting, there was no other meeting of this committee. My lord. This is the most important committee, my lord. This committee was to look after entire selection process. They were to appoint subcommittees, etc. But they have done nothing. Everything was done by the general
It's
manager.
appointment of two LDA. Why subcommittees are required? What is the substantial ground? A same condition was applicable to you and to them. Were they favored by the committee or somebody? Is it your case based on any favoritism, bias, nepotism?
That by the
Against whom?
that is why I'm talking.
Who's the officer
Even my
concerned?
lord, even my lord, here my lord, we find that the other of respondent of 4, he was given he has been given the opportunity to bring the question paper from the principal of the college. He brought the question paper, and the question paper is along with answer script. So my lord,
Where have you stated?
my lord, that is there.
Father of respondent number 4, who was he? Who is he? Is he an officer of the or employee of the?
He is an officer of the institute. He is officer of the district Introduce Commerce Center, Kolaghat,
Father of respondent number 4.
respondent 4.
What is his name?
My lord.
Which
Sir.
respondent?
He is my. He is Rajkumar Bori.
Rajkumar Buri.
Rajkumar Bori. My lord,
What is the allegation against him?
my lord, thing is that the general manager has given him responsibility to bring the question paper
Where,
and
where,
answer.
where is
So-
where is the allegation? Which paragraph?
My lord, my lord. My lord, the principal of the Devraj College, the principal of the Devraj College, who was appointed for printing the, making the question and
Where,
question.
which pleadings where?
Yes, my lord. As my lord, annexure may be seen, my lord. Annexure, page 66, my lord.
Page?
66, my lord, of the petition.
Yes.
I hereby providing you information as required to you through RTI Act that question paper which was given to me to prepare by managing director by Sender Upper Sri Rajkumar Bori, an employee of the office, who was introduced by the managing director as because he was introduced as an employee of the said office. I did not take any receipt of delivery at the time of delivery of the said question paper. Earlier this fact was suppressed by them. Earlier this fact was suppressed by them. They have replied that the question paper was collected by the
No, no, what this response you got by what made the principal write to you?
I had asked him in RTI in reply to my RTI application.
Okay, okay,
The principal replied in my RTI application.
okay.
My God. So initially,
Madam, your body or Mrs. Sharma?
my lord, initially they have suppressed the fact, my lord. Initially they have suppressed the fact, and they have told me that the question paper was collected by the general manager.
No, it's okay. Now it's revealed that
Ah.
it was given to father of
Yes,
Mr. Sharma.
That
Okay,
is why I am trying to tell you about that. Initially, they have tried to suppress. I have made RTI to the
Okay,
district
okay,
industry
okay.
center,
Hmm.
and the district industry center in annexure number 9. In annexure number 9, they said that it was collected by district industry center.
Page
This page number 33,
of
32 and 33 of the petition.
what was the question number at E, serial number E?
Question by who
Oh,
collected?
oh,
Question is at page 29.
লিখিত পরীক্ষার প্রমাণপত্র
Who collected the question paper? Who write
প্রস্তুত
written text on behalf of
জেলা
district industry
পরিষদ
trade center
আৰু
Golaghat from the question
বাণিজ্য
paper?
কেন্দ্ৰৰ হৈ কোনে সংগ্ৰহ কৰিছিল? জেনেৰেল মেনেজাৰ।
General Minister. Initially, they have tried to suppress this matter. accept your, my lord, that in fact, there was no meetings, etc. Everything was, our listening is, everything has been prepared subsequently. There was nothing, because one example I may give to your lordship. Firstly, that person said that he was never a member of the committee. As he says he was never. So by that way also, the entire selection process goes. One of the members says that he was never a member. So where is the deliberation, my lord? So and on that count alone,
Is there a statutory requirement to have this selection done by a particular committee?
my lord, there was no such statutory requirement, but they have made a selection process. Selection process was that they will
Yes,
make a,
yes.
accordingly, they
Anything
have
else,
made a
anything,
overall
anything,
selection committee.
anything else?
They have made a overall.
Anything else, Mr. Sharma?
Well,
Mr. Kulita, this person has signed, age Gam. But in the RTI, he has said that he was not even a member of the committee. Though it may not have too much of relevance in the outcome, but the entire selection appears to be done in a fraudulent manner. If there is element of fraud, then our approach should be different.
We have to record.
What does the record say? What about the signature of this particular officer in the selection proceedings? We have found that he has signed in the minutes and he has denied his presence or involvement. This is something very serious. Normally, we would not have interfered with the selection process because he has submitted to the jurisdiction, same situation he also faced. But if there is fraud involved and question paper being transmitted by one of the relatives, the father of one of the candidates, selected candidate, this gives rise to very serious doubts on the fairness. What does the record say?
Yeah, I haven't gone through the record. You may kindly pick on Tuesday, Lord.
Mr. Sharma, what do you say? You have a very limited role.
Your lordship, in my submission, S. Gam and S. Puri, Rajkumar Puri, they needed to have been arraigned
No, that is a different matter.
as parties. Now, the
We have seen that. In fact, we had grilled Mr. Sharma.
yes,
Allegations is a fraud.
the authority, your lordship, the authority are the custodians of the truth and process. In fact, your lordship, there is one threshold that I would like to take your lordship to. Your lordship kindly comes to paragraph 3 of the writ petition.
Yes.
Paragraph 3. That the petitioner had also duly applied for the post and she had been qualified in the written test held on 30/3/2015 and had been asked to appear in the computer typing test and viva along with 8 others, and her position was in serial number 6 in the notice dated 18/5/2015. In the written test, the position of respondent number 4 was the number 1, which is quite surprising considering his poor merit, the academic qualification. There were 3-tier system of examination that
Mr. Sharma, we are not even going to the
yes,
inter se merits.
yes,
You may actually be more meritorious than Mr.
Yes.
Sharma.
Yes.
But what is the procedure adopted? Taking signatures of person who is not even there.
in fact, that person ought to have been aided to the party to substantiate.
We
her
know,
case.
we see the records. RTI is denied.
We're not privy to the record. In fact, your lordship will see the
See,
the RTI
non-joinder may be fatal in some cases, but
Yes.
here the allegation is of fraud, the entire system.
the authority.
Your father got the
That
question
again has to-
papers.
There has to be a verified information because the custodian of that information communication, your lordship, with my humble submission, is the principal of that call. The authority, the respondent here, which have been narrated to the party, their submissions have
Okay,
been completely
even if we ignore that aspect of the
Yes,
matter,
yes.
what about the presence of one of the selection committee member who has put his signature and denied?
And
What do you say?
that is all the more, in fact, for the department to substantiate because they are the custodians of the rules.
Okay, tomorrow, is it okay?
Not Tuesday.
Tuesday is a non-working day. Monday is okay?
Monday,
Tuesday is not possible. Tuesday is a holiday.
okay, Wednesday, Lord.
Wednesday. And madam, what do you say?
No, my substantial allegation was that people who qualified for the written test, all of them were taken out of the test for the computer typing as well as viva voce.
See, you were winning a game. Then you are winning, only 1 run required of 100 balls. Then you also got the umpire to your side.
So that is what the umpire said, subject to a bystander saying
There was
that.
no requirement to get the umpire with you.
Officials haven't said that, Your Lordship.
You
that
are
the
you to
umpire-
play with 11, not with 13.
Absolutely, Your Lordship is completely right.
Is it required?
Your Lordship. But the fact is,
To have the umpire play
but the
with.
verification of the principle that stated that my father was involved.
Allegations, no, if the allegations are not substantiated, then we'll have a different.
Yes,
But
yes.
Here, what more can he do?
I was an outsider.
What more can he do? Get the information under RTI, get it on records. We'll verify from the records.
The RTI information from the authorities will not be to my seniors.
At least on the aspect of the bringing the
But the
question papers, that we may ignore, we have already made it clear.
Yes.
But the aspect of one person not there and his signature is appearing, though normally would not have gone into, but it amounts to a fraud on the process, entire process.
So the personal correspondences between the, and it was maybe subject to a lordship says, all the more required that.
No, it was not a personal letter, it is under the RTI.
RTI pursuant to a correspondence between the, my senior
See,
friend, Your
this
Lordship.
particular officer, he's not an individual, he's not connected with the office. He is an officer of the, if he has given a statement of this nature, he'll face disciplinary proceeding, he'll face all consequence. On his own risk, he has given the information, and all this time the petitioner, the department has not done anything with him. If the department even now says, no, the statement given by him is wrong,
My senior
he
friend
was
is
there.
VP of the-
then that would be different.
Yes.
Ask your senior to be prepared on this aspect, okay?
On
Mr. Sharma, we'll have it on Wednesday next.
Wednesday.
Okay. Heard Sri Ajay Sharma, learned counsel for the petitioner. Also heard, no, however, also heard Sri Sharma M. Sharma, learned counsel for response number 4, and Miss D. Barpujari, learned counsel for response number 5. Full stop. Para.
Yes.
Sri Ankulita, learned counsel.
ठीक.
However, learned counsel, however, has prayed for some accommodation on behalf of his senior, Sri A. Kolita,
Yes.
learned standing counsel, Industries and Commerce Department. Full stop. Para. In the interest of justice, list for consideration on Wednesday next.
Yes.
8/5.
I think so.
Yes.
So if here the petitioner is seeking conversion from Constable AB to UB on the basis of a circular of 2013.
You are seeking a conversion
Yes, sir.
from unarmed to armed branch.
Armed branch to unarmed branch.
Armed branch to unarmed branch. Okay. Then what has happened?
On the basis of a circular of 2013, Lordship,
Hmm.
your Lordship will find a circular at page 20. Lord.
Hmm.
There are some eligibility criteria.
Now
which
what has
will
happened?
fulfill.
They have rejected.
No, what they have done is they have converted women police constable against male vacancies. Vacancies meant for us.
And your thing has not been done.
No, Lord.
Yes, Mr. Nath.
But although we have not filed the affidavit in this, some instructions have received, I have, it is available. in
Can
the
you
file.
consider his case?
But I understand what I gather from the instruction is that, Lord, at that point of time, the number of women constable in the police stations are very less. That is why that.
No, that is okay. We may not find fault with you.
And
Now, can you consider his case?
the instruction is that it is a continuous process and it is going as per seniority cum merit. When the petitioner's turn will come, they will be considered. That is
See,
that is
the primary allegation
Lord.
of converting few posts
Lord.
which were meant for male constables
Lord.
into female was done for an exigency.
That-
You needed female constable. That's a
Lord.
different, but
Lord.
that will also have to be examined from the point of his right for consideration. His
Lord.
filing of an application may not per se amount to giving him the benefit. He has to fulfill the criteria of seniority.
absolutely not.
Now, at that
Seniority-
time,
seniority
Rightly
is
or
not-
wrongly, he was deprived.
Lord.
and posts have been converted to female constables.
Mal-
Now his application is still pending.
No,
You
that-
consider his application within a
that-
time-bound frame?
That's.
Do you otherwise fulfill the requirement of seniority?
Yes, not exactly here, but then we,
But while consider the aspect that at the earlier point of time, he could not be considered because of the conversion to female category. Okay,
that's it.
okay.
That's it. But along with the other eligible persons, some other senior persons are there.
Just like him, not new.
There are 30 petitioners.
Okay. There are 30
30
petitioners.
petitioners.
Oh, not one.
So, let them.
One, we could have
We have
said
already
something.
filed a
For 30,
But let them file a representation to the authority, because it is of 2018.
okay.
And as per now.
No, we'll say something. Okay.
There is already a representation from
Okay.
the
Dideka,
DTEC.
Arts Sri Dideka Learned Council for the petitioners. Whereas Sri D. Nath, Learned Senior Ground Advocate, is present for the official respondents. Full stop.
One to
Is there any other respondent?
private respondents, they have.
Official respondents.
Lots.
Full stop. Para. The facts, please have your seat. The facts as projected in the writ petition are that the petitioners are working as constables in the armed branch of the Assam Police since their appointment in the year 2001. Full stop. A circular was a circular number 4 of 2013 was floated for enabling conversion of constables from armed branch to unarmed branch. Full stop. It is the case of the petitioners that they meet the criteria laid down in the said circular, more particularly with regard to educational qualification, minimum length of service, no court case or disciplinary proceeding, and no major penalties being inflicted upon them during their tenure as constables in the armed branch. Full stop. Tara, Sri Deka, the Learned Council for the petitioners, has submitted that pursuant to the aforesaid circular, the petitioners had submitted a representation dated 21/12/2013 for such conversion, and accordingly, the Superintendent of Police, Darong, Mongoldui, had sent a list of such candidates to the Additional Director General of Police Administration on 10/11/2014. Full stop. It is claimed that the aforesaid list contains the names of the petitioners. Full stop. The petitioners were, however, surprised to learn that vide a select list dated 22/9/2015, 1127 numbers of women police constables were converted from armed branch to unarmed branch, and such women police constables were junior to the petitioners. Full stop. Para, the Learned Council has also drawn the attention of this court to an earlier writ petition filed by similarly situated persons, in which there was an order dated 14/10/2015 not to keep certain posts of constables in the unarmed branch vacant. Full stop. Para. The the contention of the learned counsel for the petitioner is that they being eligible for such conversion as per the circular in force, comma, their cases ought to have been considered and they be given the benefit of conversion from armed branch to unarmed branch. Full stop. Para. 3. D. Nath, learned State Council, has fairly submitted that factually there is no dispute with the projection made. Full stop. However, the conversion was made for women constables as there was an immediate need which was in sync with the public interest. Full stop. The learned State Council, however, fairly concedes that if the petitioners are fulfilling the criteria laid down in the circular number 4 of 2013, comma, their cases would be considered in accordance with law and seniority. Full stop. Para.
Para 14 of our instruction.
Para 3.
Para 14.
The learned State Council submits that though a formal affidavit in opposition has not been filed, comma, there are detailed written instructions forwarded by letter dated 22/11/2022. Full stop. The State Council has relied upon the response to paragraph 14 of the writ petition, which reads as follows. We'll quote this. Okay. এখন instruction or wrong amendment. The learned State Council submits that it is the categorical stand of the official respondents that the process of conversion from armed to unarmed branch is a continuous process, and as and when the turn of the petitioner would come, comma, their cases would definitely be considered. Full stop. Para.
Along with following.
Considered along with similarly situated persons. Full stop. Para. After hearing the learned counsel for the parties, comma, this court is of the opinion that due to an exercise to give benefit of conversion from armed branch to unarmed branch in the Assam Police was preferred for women police constables, which has been submitted to be as per an immediate requirement and for public interest, comma, this court may not find fault with the aforesaid action of the state, full stop. At the same time, comma, the right of a fair consideration of the petitioners for giving benefit of such conversions from armed branch to unarmed branch cannot be taken away, full stop. In view of the aforesaid facts and circumstances, comma, this court is of the view that a due consideration of the cases of the petitioners for such conversions is required to be done on a priority basis, more so when it is on record that in the list dated 10/11/2014 sent by the Superintendent of Police, Dorong, the names of the petitioners had figured, and in the meantime, almost a decade has passed, full stop. To facilitate the respondents to undertake the exercise, the petitioners may submit of fresh representation along with a copy of this order for doing the needful. Full stop. Read petition according distance disposed of. Copy of the a copy of the written instructions is made part of the records. You photocopy code. Original. You retain the original. You give a photocopy. Okay.
After receipt of the representation, they will consider it within a period of.
No, we said priority basis.
Plot.
More than a decade. We have not said any period. You do it expeditiously.
As per now.
You said it's a continuous process.
Other persons may be there.
Yes. Next.
That visual.
Yes.
My lord, there are two writ petitions. The WPC number 2658 of 2018 pertains
Same
to
petitioner.
same petition.
Okay.
The 2018 matter pertains to illegal deprivation of the petitioner of a promotion. And the other matter, his junior has superseded him. That's why it's an appended question. I held that promotion.
Okay, you're for private respondent.
No, Lord, depart,
Which department?
health department.
Health. Yes. Who's appearing? You'll be
No,
appearing.
Lord, Mr. DP Bara, he's come.
Okay, and private respondents? Number? 7. Okay. NMC, you'll be appearing?
There's a formal part.
Okay.
Indian
Mr.
matter.
Bora, can go ahead with this?
Yes, my lord.
We can go ahead with this?
Yes, my lord.
Okay.
Possible kindly take up WPC 2858 of 2018.
The earlier writ petition.
That is the main writ petition. If I succeed in this, consequential relief will follow.
Yes.
Yes, my lord, may I just indicate the facts in a nutshell?
Hmm.
My lord, the health department introduced the oncology department at Guwahati Medical College and Hospital in the year 2008. And various posts were incorporated and a paper publication was made for the post of Registrar Oncology under
Yes.
CMC. The petitioner as well as the private respondent applied, participated in the examination conducted by the
Private respondents 1, number 7.
number 7. My lord, the petitioner
Applied for the post of registrar.
registered oncology
In
the year-
GMCH.
in the year 2008.
Hmm.
And both got selected. However, the rich petitioner was he's top the list now,
Hmm.
top the merit list.
Hmm. Hmm.
Thereafter, my lord,
Both were appointed.
both were appointed as registered oncology.
How many registrars posts were there? More than one?
3 posted.
3 posts. Both appointed.
Both appointed.
Okay.
But in the merit list, the petitioner is at top.
Okay, 1. Yes,
Yes.
yes.
And then thereafter, what happened? In the year 2011, the petitioner was promoted to the next higher post, that is assistant professor of oncology.
When were you appointed as registrar? Which date? And page?
Yes, my lord.
By same order?
Yes, same order.
Date?
Yes, Lottie will kindly turn to 17/7/2009, page 48.
17/7/2009.
Page 48.
Okay.
Okay,
17/7 appointed as
Petitioner.
registrar. Okay.
Yes.
Then
There
what
is a
happened?
common list. Thereafter, my lord, on 4/8/2011,
Yes.
petitioner promoted as assistant professor of oncology. That is the next higher post.
Hmm.
Page 51 of the report.
51.
Yes.
Assistant professor of oncology.
Oncology.
Okay.
From register to assistant.
Yes, yes.
Now, as per the service rules governing the field, pilot, 2 years qualifying service is required for the next promotion, that is associate professor on faculty.
Okay.
And the promotion criteria is seniority cum merit.
Okay.
And for direct recruits, the seniority would be determined from the merit position in the commission list. Yes. And a lot of will also kindly note, on 4/8/2011, when the petitioner was promoted as assistant professor, the private respondent was still a registrar.
When was he promoted to assistant registrar?
He was promoted on, my lord, 9/9/2014. 9th of September 2014.
R7 promoted as assistant professor.
Assistant professor on 9/9/2014.
Okay. Which is almost 3 years thereafter.
Yes,
After you,
almost
after
3
you.
years.
Okay.
Anyway, my lord, the issue is now I became eligible for promotion to the next higher grade, that is the associate professor of oncology. And in this regard, my lord, a certificate was issued by the department on 27/8/2012 regarding my experience. 27/8/2012. That is at page 52 of the
Experience certificate.
experience certificate, special training certificate.
Then what happened?
Then in the year 2013, at the DPC met, there were other posts also which the DPC considered, but in respect of associate professor, they said that they, in a remark column, they endorsed that no eligible candidate found. And I was not made aware of that DPC met.
But you said that you were promoted in 4/8/11.
2 years qualifying services.
No,
required.
and in DPC was in 13.
Yes.
Was it after August?
My lord, it was the first DPC met on 22nd of November 2013.
After August.
After.
That means 2 years thereafter.
Yes.
You fulfilled 2 years.
Yes, 22nd of November 2013, the DPC said.
Your case not considered.
In the remark column, they endorsed that no eligible candidate found in respect of associate.
You are not even aware.
I was not even made aware at that relevant point of time. In respect of associate professor oncology.
Okay.
Thereafter, again on 9/9/2014.
Okay, second DPC.
Yes.
Another
Second-
DPC.
Another DPC met. Again, my lord, this time also, same remark was that no eligible candidate found for associate professor. And in this time, private respondent number 7 was promoted from registrar to registrar.
Okay, doesn't matter.
Yes.
That you have said 9/9/14.
Yes, 9.
Okay.
Now, my lord, I preferred a representation as well as some RTA application.
Okay.
Yes. Now, these office notes are very important, my lord, that I will have to pay. Doctor will kindly come to page 81 of the writ petition, 81.
Just a minute, please. Eighty-one.
81, yes. This is the office note obtained under RTI. The first para. In this regard, to the two incumbents, that is Dr. Lohit Kolta, that is the petitioner, Assistant Professor of Oncology Department, and Dr. Swenso, Assistant Professor of Urology Department, the both being related to super specialty department, 2 years service as assistant professor in their respective disciplines, qualify them for promotion to the next higher post, that is assistant professor in the state discipline. Both of them have completed 2 years of service as assistant professor and are thus fit for next promotion. Now, Lordship will kindly turn to the next page, page 82. The Honorable Minister's note in the government file regarding promotion of Dr. Lohit Mohita from the post of assistant professor to associate professor of oncology, as noted, it appears that government has one order dated 20 certified as such. This is to certify that Dr. Lohit Mohita, assistant professor of oncology department, Guwahati Medical College and Hospital, Guwahati, has been working in the Department of Oncology and Hematology of Guwahati Medical College and Hospital, Guwahati, for giving oncological service like treatment of leukemia, etc. since 1/8/2009 and completed 3 years. The state period of rendering services in the Department of Oncology and Hematology by Dr. Lohit Mohita may be counted as special training in the hematology and oncology. This institute is recognized by Medical Council of India, placed in government file. This fact was not placed before the DPC. The certificate which certifies me, that is 27/8/2012, as I have already mentioned, certifies me that I am already the requisite qualification I have acquired. But this fact was not produced, and the prepaid note says I am fit and eligible for promotion. So, my lord, I filed a writ.
The earlier one.
Yes. No. Prior to this is the second round, my lord. In the year 2016, I prepared a writ petition.
Number?
My lord, that is WPC number 1395 of 2015.
Okay.
Yes. Now, in that, I said, my lord, why I was not promoted. And the health department, in their affidavit in opposition, took a categorical stand that this certificate of 27/8/2012 cannot be counted because, my lord, as per the rules, it says 2 years of teaching experience in surgical oncology or medical oncology.
Yes.
That is, my lord, under I have annexed the MCA guidelines. The MCA guidelines say for being eligible for promotion to associate professor, you will have to have a teaching experience either in medical oncology or surgical oncology. But as you have noticed, in Guwahati Medical College and Hospital, there was a composite oncology department. There was no bifurcation till then. It was only oncology department. So accordingly, the certificate was issued accordingly. And that was the stand of the health department in their counter affidavit.
Yes.
Yes. My lord, this honorable court, after due consideration of the arguments placed by the contesting parties, by judgment and order dated 19/8/2016, page 116 to the writ petition. Judgment.
1395.
Pardon, madam.
1395.
Yes, 1395 2015.
That was
disposed
disposed of.
upon 19/8/2016.
1916.
Yes, at page
116.
116. Before that, my lord, I will just, I'm sorry, their affidavit in opposition I must place.
In the earlier round.
In the earlier round.
Okay.
Page 100 it starts at page 110. Relevant portion is at page 111.
That you have already stated that their stand that it is not.
Yes, it was, Lordship will kindly note, affidavit in opposition at para 4 and 6. Para 6 is more relevant. It was placed before the learned single judge in 100, para 6. That is at page 111 of this petition.
Yes.
Now, Lordship will kindly come to the learned single judge topic. Lordship will kindly turn to page 125, this petition. 125. I'm only referring to the relevant portion of it.
Yes.
Para 17 down below, at page 125.
Hmm.
Turning to the affidavit in opposition filed by the respondent number 1, the statement at para 4 thereof to the effect that the petitioner's case for promotion was not considered for not having diploma of 2 years training in oncology from a recognized medical institute. The same do not find support from the MCA regulations of 1998. This is a statement made out of context. In this respect, Rule 11.1.2 of the Rules of 2008 makes it amply clear that a member of service holding the post of assistant professor, senior scale 1, is eligible for promotion to the rank of associate professor, senior scale 2, in accordance with MCI regulation. A close reading of the regulations of 1998 do not envisage the requirement of a diploma of 2 years training as stated in the state paragraph 4. Also, the statement at paragraph 6 of the affidavit in opposition to the effect that the certificate dated 27/8/2012 is not a valid document as prescribed by the MCI guidelines for the purpose of promotion to the post of associate professor. The same do not find to reason. The MCI guidelines do not lay down any format for a certificate to be deemed as a valid document, nor the contents of the certificate dated 27/8/2012 can be brushed under the carpet, short of an opinion as to its value rendered by a subject expert. Para 18, my lord. The discussions above lead to the inevitable finding and decision that the case of the petitioner for promotion to the rank of associate professor in the Department of Oncology requires a relook. Such exercise is to be made with a subject expert of the discipline concerned, present as a co-opted member in the selection board. Accordingly, a direction is made to the respondent number 1 and 2 to constitute a selection board in terms of sub-rule 1 and 2 of Rule 15 of the Rules of 2008 for the purpose of considering promotion of the petitioner to the rank of associate professor in the Department of Oncology and to furnish to the state selection board all documents and information pertaining to the petitioner in strict terms of sub-rule 2 of Rule 14 of the Rules of 2008, together with the certificate dated 27/8/2012. While undertaking the exercise, this is very important, Lord will kindly mark this. While undertaking the exercise, the selection board shall not be influenced in any manner by the stand taken by the state respondent in paragraph 6 of the affidavit in opposition, wherein a statement is made that the certificate dated 27/8. Lord will kindly mark this because they have violated this direction. Lord will kindly mark. So there is a categorical direction to the authorities not to be influenced by the stand taken in the affidavit that the experience certificate granted to me is not a valid document.
Yes.
Now, my lord, the learned single judge, however, did not grant me the relief of my lord promotion from 2014. The retrospective effect was not granted. So on that limited prayer, I, my lord, preferred a retake. On that limited prayer. Because, my lord, if a review DPC has to be undertaken, it is the essence of an original DPC. Either it has to be a review DPC of 2013 or 2014.
Okay.
So, to the extent of not granting me retrospective effect, so I prefer the writ appeal. The writ appeal order is at page 128 and Extra 17. The division bench order, I am relying on para 10 and 11. It's order dated 13/2/2017. Starts at 128. Relevant portion at page 133. Para 10 and 11, I will read. May I read it? At page 130. What is significant here is that the learned single judge found the respective exercise undertaken by the selection board on 22/11/2013 and 9/9/2014 to be faulty and not in accordance with the applicable norm. Hence, direction was issued for appropriate reconsideration. The duty constitutes a selection board. Naturally, the ordered exercise should be undertaken from the date of deprivation, that is 22/11.
Okay, that was so do you consider the retrospective effect
Yes.
also aspect also?
Now, my lord, these two orders were placed before the authority for convening a review DP in respect of promotion.
Okay.
They set over the matter and I file a contempt case before the Honorable Division. Because the learned single judge gave them a time limit matter at para 18 of the single judge's order.
Okay. Then
Then when the news was tightened in the contempt case, same day the review TPC set and same day the order was passed. Interesting, my lord, the stand taken in para 6 of the counter affidavit, which the learned single judge barred, that was taken, my case was rejected and they have gone one step ahead. Now the review DPC is tinkering with my promotion from register to assistant professor.
when was this?
The
When was this?
impugn minute, your lordship at page, this is what I'm telling you, 144. It was on 2nd of April 2018. And the minutes has been copy pasted and converted to into order. 2/4/2018 at
144.
1:44 at 3 p.m. Minutes of the review selection board meeting for considering promotion of Dr. Lohit Kolta, Assistant Professor of Oncology, held on 2nd of April 2018 at 3 p.m. in the office chamber of Friends. Now, my lord, as I have already stated, as I have, my lord, already stated, a review DPC is only an extension of the original DPC. So they ought to have confined themselves to my promotion from assistant professor to associate professor. However, as a vindictive measure, they are now also tinkering with my promotion from register to assistant professor. Doctor will kindly see at page 145. A, from register to assistant professor. Well, under which jurisdiction now they are considering in the review DPC my promotion from register to assistant, I don't know. And B, from assistant professor to associate professor. Serial number 4. The committee examined the minutes of TPC meeting held on 5/7/2011, that is from register to assistant professor, in which the promotion of Dr. Lohit Kolta from register to associate professor was recommended. It was stated in the minutes that the promotion was recommended on the basis of certificate given by Dr. P.K. Gogoi, the then professor and HOD of Hematology, Guwahati Medical College Hospital, Guwahati, which stated that Dr. Lohit Kolta, MS Orthopedics, Register of Oncology Department, Guwahati Medical College and Hospital, Guwahati, has acquired 2 years of training in Hematology Department in Oncology and so. In the discussion, Director of Medical Education, Assam, has also stated that the state training is eligible criteria for promotion to the post of assistant professor in Oncology Department as per MCA norms. There is no departmental proceeding, criminal proceeding pending against Dr. Lohit Kolta. 5. The committee, after deliberation, observed the following in respect of promotion of Dr. Lohit Kolta from register to assistant professor. Dr. Lohit Kolta was MS in orthopedics. He can therefore be eligible to work in surgical oncology, that only after being properly trained in the Department of Surgical Oncology from a recognized institute. Therefore, even even if his tenure as registered in Department of Hematology is considered, he cannot be eligible for the post of assistant professor in surgical oncology. While the certificate issued by Dr. P.K. Gogoi, Professor of H30 Hematology, was in respect of training acquired, the MCI requirement was 3 years teaching experience and not simply training. Therefore, the certificate did not fulfill the MCI requirement for promotion from the post of registered oncology to assistant professor oncology. Further, the Guwahati Medical College and Hospital is the MCI recognized institute, a self-contradictory might. However, the Department of Hematology is not recognized by MCI for postgraduate teaching. Hence, the above mentioned certificate is not valid for this perspective too. The committee, therefore, next page, my lord. The committee therefore opined that Dr. Lohit Kolta was not eligible for promotion from registered to assistant professor and recommended that the health department may review the promotion. Now they're tinkering with my promotion held in the year 2011, which was not even the subject matter. Just because I preferred a case against them. Next part. The committee, after deliberation, observed the following in respect of promotion of Dr. Lohit Kolta. Sorry. Next part. The committee, after deliberations, observed the following in respect of promotion of Dr. Lohit Kolta from assistant professor to associate professor. A. As mentioned at 5C above, the Department of Hematology is not recognized by MCI for postgraduate teaching. Therefore, Dr. Lohit Kolta does not have the required qualification of serving as assistant professor in the concerned subject, Department of Hematology, Surgical Oncology, for 2 years in the recognized medical college. Any certificate, including certificate dated 27/8/2012, issued by the Joint Secretary Health and Family Welfare Department, that rendering service in the Department of Oncology and Hematology, Dr. Lohit Kolta may be counted as special training in hematology and oncology, would not meet the MCI requirement as assistant. The bar created by this honorable court is being blatantly operative. The committee therefore recommended that Dr. Lohit Kolta was not eligible for promotion from assistant professor to assistant professor. The review selection board meeting concluded, and thereafter, my lord, the order has been passed at page 148 by copy pasting the state minute. At 3 p.m., review DPC sits, and same day the order is also passed at page 148. Thereafter, I immediately filed the present date petition, and this honorable court has been pleased to stay this order. And during the pendency of this petition, on December 2019, respondent number 7, who is having similar experience, because the Department of Oncology in the Guwahati Medical College is a composite department, there is no bifurcation. So, on December 2019, he has been promoted to associate professor by superseding him. And in the second petition, I am stating that there are 2 posts of associate professor. If in the event if I succeed, his promotion may not be such, but my seniority has to be restored. In the event I. And my lord, another aspect is that since on the earlier occasion, this honorable court has limited the matter back to the DPC, and this is what they have done. There are judgments of the Honorable Supreme Court. So, normally in promotion cases, the Honorable Court should direct for consideration and should not pass any positive direction for promotion. However, here the stage has done, and lordship can pass a positive direction. There are directions of Honorable Supreme Court. And I will be praying for a positive direction in this matter, because if the matter is limited back to the authorities, same thing will happen. And these members of this review DPC also will kindly turn to page 144 for once, my lord.
In the second case, what had happened? When was private respondent promoted?
Private respondent was promoted to the post of associate professor,
R7.
R7,
When?
on my lord 31st of December 2019. That's it, correct.
3112,
31/12/2019, annexed 24 of the that petition.
new writ petition.
That's it, 2020. And this honorable court, while issuing notice, has made that promotion subject to outcome of this petition by the order dated 4/6/2020. And in this writ petition, while order dated 9/8/95/18, the impugned order has been stayed.
Nine eight,
9/5/2018, the impugned order of the review DPC been stayed.
24 was stayed.
Yeah.
2418 was
Yeah.
stayed.
Order dated 9/5/2018.
By, yes, order of this court is 9-5, impugned order was 2-4.
But we'll kindly turn to one interesting aspect. Page 144 of the petition,
144.
144. That is the minutes of the review DPC on 2/4/2018.
Mm.
The lordship, these are the members who are present. Serial number 2, Ubaligwa STS, she issued the certificate which I am relying on. Certificate dated 27/8/2012. The certificate is annexed at page 52 of the report. And serial number 6,
Hmm.
I have also issued certain certificates in my favor regarding my experience. Those are annexed at page 151, 152, 153, and 154. Now the same authorities, they're blowing hot and cold. Page 151, 152, 153, and 155. Certificates issued in my favor by this. So this is my case. Lordship will I humbly pray that Lordship will interfere with the impugned order as well as the minutes of the DPC, review DPC, and issue a positive direction to promote me, my lord, from the year 2014 at least. And my seniority may be restored vis-a-vis the respondent number 7. And I can place the rules that it is a seniority come merit basis. As for direct recruitment, it is a merit position in the commission list. The rules prescribed so.
Okay.
But I'll be relying on two judgments. I'll not tabulate also, I'll just give the two copies. One for the proposition that a review DPC is the extension of original DPC. And
Citation.
my lord, 2018, 1 SCC, page 552, para 21. Correct.
Name.
My lord, Union of India versus Major General Manomoy Ganguly, para 21. Here also, my lord, the review DPC is to deviate, but the Honorable Supreme Court has said nothing doing. It is an extension of the original DPC. You cannot. Para 21.
Okay.
And
22.
the other citation
Para
is
22, you have said. 22.
para 21.
21.
And the other judgment is, my lord, 1979 2 SCC. One 79 2 SCC 150. The district register Kalighat versus
Para,
my lord, para 30. The district register Kalighat versus MB Koyakutti. My lord, here also, my lord, a positive direction was issued by the Honorable High Court for promotion, and Supreme Court has upheld it. The given facts and circumstances. So, my lord, that is my respectful submission. Lordship will kindly allow this writ petition and restore my seniority, and also issue a direction to the authorities to promote me to the post of associate professor.
yes. Mr. Bora.
My lord, only issue involved is regarding the eligibility of the petitioner for promotion, my lord. So the eligibility, my lord, if your lordship takes up my affidavit at page 183, my lord. So eligibility criteria stipulates the eligibility stipulated by the MCI, Medical Council of India, my lord.
Page?
Page 183. It's a part of the minor, my lord.
Just a minute, please. It's a part of your affidavit
Yes, my lord.
filed on 5th of March.
Yes, my lord. And it is page 183, the part of the minute. Yes, my lord.
183.
Yes, my lord. Part of the minute dated 4/2018, my lord.
Yes.
Eligibility criteria has been stipulated here, my lord. So from registrar to assistant professor, my lord. Requisite recognized specialization qualification in the subject. So, my lord, the petitioner is orthopedic, he is MS in orthopedics, my lord. So his qualification is that, my lord.
The entry point of visa was
Yes, entry point. Then, my lord, 3 years teaching experience in surgical oncology in a recognized medical college as resident registered demonstrator tutor. So, my lord, in this case, thereafter, my lord, it has been contended that, my lord, the professor and HOD of hematology department issued a certificate, inter alia certificate certifying that the petitioner has worked in the hematology department for 3 years. But, my lord, the criteria, eligibility criteria requires that 3 years teaching experience in surgical oncology, my lord. So, my lord, for the petitioner, my lord, the certificate was issued by the head of the hematology department that he has worked in the hematology department, my lord. So, accordingly, he is not eligible for promotion to the post of assistant professor, my lord. Initial promotion, my lord. Because, my lord, in the year 2009, my lord, he has been appointed as Registrar Oncology, and, my lord, his qualification is MS in orthopedics, my lord. And that certificate has been issued by the HOD of the hematology department. So certifying that he worked in the hematology department. So, my lord, the specialization qualification and the certificate both are from the 2 different departments. And here, my lord, it requires that 3 years teaching experience in surgical oncology in a recognized medical college as resident registered public demonstrator. And second contention is that, my lord, the hematology department, my lord, that is a super specialty department. Although, my lord, Guwahati Medical College Hospital is a recognized institute, but the hematology department, my lord, that is not recognized by the MCI, my lord. That sorry, my lord, the surgical oncology department of PMC is not recognized as a teaching department by the MCI. Then, my lord, the present promotion from assistant professor to associate professor. As per-
Mr. Patwari, you were saying 2 years. Why
Yes.
2 years? No, 3
Yes,
years.
Rachel,
should-
kindly come to the rules, man.
No, my lord. For
Wow.
promotion from assistant professor to associate professor, that is 2 years, my lord.
2 years, okay.
That is 2 years.
Or initial was 3 years. From
Initial
where-
years, but we are the first batch.
Okay.
That is 3 years, my lord.
And Lordship has not read that, they are saying that the certificate issued by the hematology. Lordship, kindly see, the certificate I am relying is at page 52, annexure 4 of my writ petition. That is not a hematology department certificate, my lord. The honorable court has upheld this
No, no,
validity,
wait, let me come to it. Yeah.
page 52. This is the certificate I am.
That is, my lord, a certificate issued certifying that he was working in the hematology department, my lord. That is the
Oncology and hematology.
yes, my lord.
Department of Oncology and Hematology.
Hematology, my lord.
His appointment of registrar at page 49 is in the oncology department
Yes,
of
my
the
lord.
GMC.
Yes, my lord.
Now you consider him to be eligible and promote him to the post of assistant registrar. Okay,
Assistant professor.
assistant professor
Yes, my lord.
on 4/8/2011.
Yes, my lord.
4/8/11/2011
Correct.
at page 51.
My lord, that's why, my lord, now the review DPC has appointed and the impugn order passed by impugn order at page 193. It has been observed that, my lord, that promotion was not also in terms of the
Can
MCA.
you go to that aspect?
Yes, my lord.
Is it within the ambit of a review DPC?
My
You
lord, if-
consider his promotion from assistant to associate, you go back to registrar and question his promotion. Was it the issue even?
My lord, issue was for promotion to the from the post of assistant professor to associate professor.
Correct.
But, my lord, if, my lord, at any point of time some illegality is
No,
found out-
was it the purpose of sitting the review DPC?
No,
Did
my-
you sit on your own or was
No, my
it
lord.
because of the court's order?
But while examining the case of the petitioner, the review DPC then only found that, my lord, as per the MCI guideline, my lord, the petitioner was not, in fact, my lord, eligible for promotion to the post of registrar, assistant professor, my lord.
When did you take the decision? Only because the court has remanded the matter
Then only it
for the
was,
aspect of considering his promotion?
yes, my
Was
lord.
that a matter of discussion?
No, my lord, that was
Should-
not. That was not. But, my lord, that was detected at that
No,
point of time.
detected, but why did it come into the minutes?
No, in the minutes, it was not there, my
It is
lord.
there. It is there in the minutes. Just now you have read.
No, my lord.
Yes.
That is on the recommended, on the,
Yes, from registrar to assistant professor, 145.
that is not minutes, my lord. That is the order, impugn order, my lord.
That is even worse. Why not minutes? 144 is the minutes. 144 is the minutes.
184.
144 or 184, whatever is.
Yes, my lord. That is
2nd
the-
April, 2nd April.
Yes, my lord.
Those are the minutes. It's
Yes.
not the order.
On the recommendation of the minutes, there an order has been passed, my lord.
If you are at 182,
Yes,
same
my-
page as 144, you come to the next page, 183.
Yes, my lord. That is the minutes, my lord. So the-
Yes, minutes from registrar to assistant professor, you make a discussion.
Yes, my lord. Yes, that is there. Page 184.
And you come to page 184,
Yes, my lord.
first line, committee therefore
Yes, madam.
opined. So so-and-so was not eligible for promotion from registrar to assistant registrar, and the department may review the promotion order.
My lord, that is there, my lord, but that may not
If
be.
you are trying to show your might, we know
Yes,
what
my
to
lord.
do.
Yes.
If it's a question of your showing your power and might,
No, my lord.
we know how to cut
Actually,
down
that is
size.
not there, my lord, probably, my lord.
If this is
because
how you exercise powers,
in terms of the rules, my lord, when it was shown that, when my lord.
is it equitable? Is it fair?
To that
After an
extent, my lord,
education, why is the education process here for? Why
to
do you
that
come to the
extent, my
court?
lord, for the post
If you
of-
take decision and you judge your decision to be fair and good, what is the necessity of a court adjudicating?
Yes, my lord. Regarding that, my lord, from for promotion from the post of registrar to the assistant professor. my
Matter
lord,
was
that may-
decided
Yes, my lord,
after hearing parties.
that may not be.
It went to the division bench, said you even expect question of the retrospective effect is also would be one of the consideration. You don't do anything. Contempt comes.
Yes, yes.
Third, before the matter was listed on third. Second, you sit. You find fault with the initial promotion also.
No, that is, that may be kept aside, my lord.
No, why should we keep aside? Your submission will not make it clear. It's reflected in 184.
Yes, sir.
You have recommended for review.
Because, my lord, otherwise, my lord, that eligibility criteria, my lord. that
No,
was
you
not
may
fulfilled.
have a good ground
Yes, my lord, I
of
understand.
eligibility, but how are you proceeding with this case?
My lord, actually, my lord, the person sitting over there, they are not acquainted with the legal obligations or terms, my lord.
No,
Maybe
it's not a
because
question of legal obligation. It's question of acting fairly.
Yes, sir.
You may not be legally trained, but you need to act fairly. You are holding some power. Whether you are exercising the powers fairly, transparently, or it seems that you are vindictive. He comes to the court passes an order after hearing both the sides. If you are aggrieved, you can file an appeal, go ahead. But something has to come to an end, logical end. That is what the system is. You cannot be super courts. There are appellate forums. Approach the appellate forum. It was adjudicated, went to the DB. DB again said, now you go back and even present a consideration for denying the appointment from assistant professor to associate professor. Simply very, very perfunctory.
My lord, this,
You create a situation that he is not in the teaching job. It's a
Yes.
consolidated department. Do you have a surgical aspect of oncology in GMC?
No.
Then can he be put to fault? His appointment as a registrar,
yes, my lord.
it was by chance in oncology department.
No, my lord, that part may be kept
Now
aside, my lord.
for all times to come, he cannot be given any promotion in spite of completing.
No, my lord, because if for the from post of assistant professor to associate professor, if we see the, my lord, eligibility criteria,
Yes.
it states that as assistant professor in the concerned subject for 2 years in a recognized medical college.
Yes, you say that MCI has recognized GMC.
MCA is recognized,
Hmm.
but that surgical oncology department, that is not recognized. If your lordship comes
Is
to,
there any objection by the MCI?
no, that has to be recognized. If your
No, is
lordship
there any
comes,
objection by the MCI regarding this promotion? Is there any issue raised by the MCI?
my lord, that part, for the
See,
purpose
you
of,
cannot do something which is not permitted by law. We cannot
Hello?
give promotion to a person who is not eligible.
Yes,
That we are
sir.
not asking you to do.
yes, sir.
But the facts and circumstances make it clear that he is a fit case for being promoted, considered for promoted. And how did you promote, how you
Yeah.
promoted the respondent number 7?
Response number 7, my lord, that part, they will say, my lord.
No,
whether
he are
he-
promoted. Why
Yeah.
they'll say they are the beneficiary? We may not find fault with them.
Response number 7, my lord,
They have been promoted.
that is a matter of the second writ petition, my lord.
Whatever.
Yes, my lord. But my
In
lord,
fact, that is
before
one of the
before-
questions we are putting to you. We had
yes, my
formu-
lord. My lord, before
formulated
that,
some questions.
if your lordship
First
comes,
is what is the criteria?
criteria,
And how does the petitioner does not fulfill the criteria? Number
page
3,
188.
how respondent number 7 is different from the
Yes, my lord.
petition?
First question is criteria has been stipulated, and second question, my lord, that my lord, how he doesn't fulfill, that is at page 188, if your lordship peruse it.
That we are not going to, this is consolidated department. And how have you?
No, my lord, page,
How have you given the promotion to respond over 7?
yes, my lord, that I will have examined, my lord. But in page 188.
R7 was also inducted as a registrar in the oncology department.
Yes, my lord.
And we are not on the grounds of seniority, whatever. Same order, whether Patwari will get march over seniority, that's a different. But the basic order of promotion,
Yes, my lord.
which you are finding fault with the petitioner, you give a similar benefit to the respondent. How is
That-
the respondent differently placed?
So I will come to the
You
first
will come,
question. Yes, my lord.
2 o'clock.
Second question, yes, my lord. Sure. Okay.
Yes, Mr. Bora.
My lord, the educational qualification of the private respondent is he is MS in ENT method. So, and in what context or on the basis of what certificate he has been promoted, my lord, that is not set now. And secondly, regarding the eligibility of the petitioner, my lord, if your lordship peruses page 1,
He is an MS in surgery.
orthopedic.
Surgery.
Yes, orthopedic.
Orthopedics.
Not surgery.
I am MS in orthopedics.
Orthopedics.
While entering service.
And worked in in the hematology department for 2 years.
That was for registered.
As a registered
And R7 is in the department, is MS in ENT.
ENT, my lord.
You don't have the instructions of how R7 was
No, my lord, on that I don't have.
from a registrar to assistant and assistant to associate. Okay. Anything else?
And secondly, my lord, regarding the second query put by your lordship, my lord, that is at page 188, my lord.
188.
Yes, my lord. Regarding the eligibility of the petitioner, my lord.
Yes.
Page 188, Annex 3, my lord.
188. Yes, please.
For promotion to the post of associate professor from assistant professor in the Department of Surgical Oncology, the requirement as per MCI guideline is as assistant professor in the concerned subject for 2 years in the recognized medical college. That is relevant, my lord. So GMCH Guwahati is a recognized medical college by MCI. The Surgical Oncology Department of GMCH is not recognized as a teaching department by the MCI. Hence, Dr. Lohit Kumar Kolita is not eligible for promotion. No record is available in this directorate regarding Dr. Lohit Kumar Kolita undergoing 2 years training course in oncology department in institution recognized by MCI. The certificate issued by the government bearing number so and so dated 27/8/2012 that he has been relied on in respect to Dr. Lohit Kumar Kolita may be considered as working experience but not as teaching experience. Because the eligibility criteria requires the teaching experience, not working experience.
Okay.
So in my humble submission, my lord, due to non-fulfillment of eligibility criteria as stipulated by the MCI, my lord, the petitioner is not eligible for promotion from post of assistant professor to associate professor at this stage.
Who is what is the name of the private respondent?
My lord, Pedul Kumar. Pedul Kumar, sir.
Okay. Yes, anything else? Okay. Yes, madam.
Section, page 119 in the petition 296 topic. Uh,
119.
my lord, my applicant of
R7. What is your name, madam?
Dr.
Your name?
My name T Wapangla on behalf of R
T.
Wapangla.
Please give your name.
My
Okay. Okay. Yes. 120 is your.
119 is my my lordship turns to 126 .6. Like I was selected to the post of Registrar of Oncology on 27th May 2009. Thereafter, in brief, my lord,
Page?
120
Yes.
point number 6. I was selected to the post of Registrar of Oncology.
No, no.
on
You're referring to which page, which rate petition?
my 2020.
2293.
Yeah, my 2293, my lord.
Your reply, if you rejoinder, opposition.
My lord.
Okay, it is 123. It starts at 123. Middle Kumar Sharma.
My lord.
Point number 6.
Yes, yes, my lord. I was selected to the post of Registrar of Oncology on 27th of May 2009. Thereafter, on 28/10/2014, on the recommendation of selection committee meeting held on 9/9/2014, I was promoted to assistant professor. My lord. Coming to point 10, my lord, with regard to my qualification, I work at Dr. B. Borua Cancer Institute as a senior resident doctor of head and neck oncology from 11/11/2004 to 25/7/2009.
Where did you what did you work?
I work as
Where have you stated?
Dr. B. Borua Cancer Institute. Point 10. Fine.
You there is a teaching job in B. Borua Cancer Institute. Isn't it a hospital?
Yeah, I work as a resident of doctor.
It's not a teaching job.
Coming to that another point, like
If it's a no, we are not finding fault with you.
uh-huh.
They are trying to say that he had worked, but that working is not teaching. So the same parameters will also be applicable, should have been applicable to you.
No, my lord, I have qualification in teaching also, and on the last part of the
2004 to 2009.
Thereafter,
in B. Borua.
yeah,
Thereafter in 200 bedded cancer hospital, GMCH. Now State Cancer Institute from 16. Where is your teaching?
Lord, when your lordship see the last part of the last paragraph of this page, as per the regulation 1998, the answering deponent has fulfilled all the criteria for the selection of associate professor. His 13 publications have already been published in text international journal.
No, those publications, we are not too
And
much
then-
concerned. We are concerned with the teaching aspect, which the department is harping
My
upon.
lord,
That working will not do, it has to be an experience of teaching.
I need instruction.
You
As
are
per my instruction, he fulfilled the eligibility criteria.
saying fulfillment is not enough. How have you fulfilled? That is what we are examining. Respondents are saying, official respondents are saying the petition doesn't fulfill in spite of being working for more than 2 years, period. They are trying to differentiate between teaching and working. The same differentiation will also come to you. Vibhora Cancer Institute is not a teaching job. It's a pure profession, a pure job of a doctor rendering his service. And even in the Cancer Institute of GMC, it's a service-oriented job. Nothing to do with teaching.
So, can you explain me sometime? I'll read tomorrow or night.
So see, if the petitioner is not after you, he's only trying to make out a comparison that
The petitioner produced the document as of now, but then like my instruction is like he have qualified the particular criteria of qualification.
on the same criteria, you are held to be eligible, the petitioner has not been held to be eligible. The department says that they are not even aware on what basis you were promoted. He doesn't have instructions. Okay. We will close this.
One short reply regarding working and teaching method.
Yes.
So will kindly take my WBC 2858 of 18.
नाम तो ले लो, हाँ. 2,
2858 of 18.
first one.
First one.
Yes.
Lord will kindly turn to page 151. 151. This is a certificate issued by the Principal cum Superintendent Guwahati Medical College and Hospital. This is to certify that Department of Oncology of Guwahati Medical College, Guwahati, Assam, is a combination of medical oncology and surgical oncology departments, was created by government notification dated 19 March 2008. So it is a composite department, as Lordship I have already submitted. Now Lordship will kindly turn to page 153. One five three. Again by the same authority matter. Certified that Dr. Lohit Kumar Kolita, that is a petitioner, Assistant Professor of Department of Oncology, Guwahati Medical College and Hospital, Guwahati, has been working and teaching in the Oncology Department, Guwahati Medical College of Guwahati, as shown below, as a registrar from 1/8/2009 to 4/8/2011, as Assistant Professor from 5/8/2011 to till date. So, my lord, this belies the contention of the my lord state respondent. And these certificates are not disputed.
Okay.
So my humble submission to
Okay.
allow this inspection.
Heard.
And lordship, those page number of service rule and the regulation.
Yes.
Service rule lordship will find at page 53 of this petition, first one. And the MCI regulations at page 67. I'm deeply open.
Heard, huh? So. You are for?
MCI.
What is your name? MS Hussain. For MCI. On behalf of DK Buddha. For MCI. Okay, and Mr. Hazarika, you're also appearing. No, okay. Bora and Madam, huh? Hearing is concluded, judgment is reserved. Okay, we'll consider. No, MS Hussain, on behalf of D. Buddha.
Much obliged, Your Lordship.
Itu tolerant.
Agree that Melot, they may be taken up any other day, Melot, after 15 Melot.
What is the matter?
Letter regarding promotion, Melot, that the client wanted to engage another advocate, senior advocate, that time Melot, I am saying.
On the
After
prayer of
15.
Anna C. Goswami, learned counsel for the petitioners, submits that a senior counsel would be engaged in this matter, for which he has prayed for some time. Footstop para. List after a week.
Melot, after 15 Melot, that any date, Melot.
List after 2 weeks.
Public.
Okay. Sri P. Hendik, learned standing counsel PNRD, and Sri S. Midi, learned standing counsel AG are present. Yes.
Finally, see one order dated 1/2/2024, my lord.
1, 2.
2024. There is an order to place the record before this honorable court, my lord.
Yes.
But there's similar matters pending, my lord. Not may tag them
This
all
is not
together and
that,
get-
my lord. This
No.
is not.
Similar matter means what is the subject?
Then I'll say, my lord,
I mean-
similar matters are disposed of by this order, my lord. Lordship kindly. Same order. Everything same,
Mr.
from
Hendik,
same block.
have a look.
Then my lord may hear the matter only on merit.
Then my lord, lordship may hear the matter. I start.
But records
Order is there, my
you
lord.
have.
My lord, they need some time. to
Get the
produce.
records.
Okay.
Short date, my lord. I am out of job, my lord. For there, my lord, illegality, my lord.
1 week time maybe.
Okay.
The date may be fixed. my lord.
Sri P. Hendik, learned standing counsel PNRD, prays for some more time to obtain the necessary records. Full stop para. List on when?
Short date, my lord. Short date. I pray for subject to lordship recommend.
Today is today is 2nd. We'll have it on can we have it on 14th? 14th you get the records.
Lordship.
14th. एक नहीं Friday.
May I please, the petitioner was appointed as a sub-inspector of police, my lordship.
Sub-inspector.
Yes, my
Okay.
lordship.
Then
Thereafter, he was unauthorized absence, therefore he was dismissed from service.
okay. Yes.
So before your lordship was an SI of policeman. He was with a pen. He was there was an unauthorized absence from 2013 to 18, my lord.
5
Go-
years.
Yes, 5 years.
Why?
And the so-called notice was issued to him. He gave a detailed reply, my lord. And their inquiry was conducted against him, my lord. And thereafter, a second so-called notice was issued to him. Basically, I agree by that, my lord. That your lordship will find
Yes.
the inquiry was conducted by the SP, my lord. And of special branch Kailipara, my lord. That your lordship pays 53 mile. Is the order of second so-called notice. Peruse the reply of second so-called that was the order for inquiry, my lord. That is page 53 mile. Peruse the reply of second so-called and pilot Sar Basumatari is thereby appointed as a presenting officer, so and so. Thereafter, a finding of the inquiry report was communicated to me, forwarded to me, my lord, by letter dated, your lord will find at page 57, my lord, Annexure 10, my lord.
Let's go chronologically to 3/1/2019
Yes, my lord.
was the so-called notice.
Yeah. First so-called notice was issued on 3/1/2019.
You had filed reply.
We have submitted my reply, my lord,
When?
on the same day, my lord.
Same day.
Same day, my lord, that 3/1/2019.
Reply.
Then
Sir?
my reply was not found to be satisfactory, my lord. And they have decided to go for inquiry. An inquiry officer was appointed. That is page 53,
Yes.
5/1/2019, my lord. Thereafter, my lord, inquiry was conducted. Inquiry report was forwarded to me by page Annexure 10 by letter dated 17/3/21,
Page.
page 57. There you will also find this is letter written by the Superintendent of Police SBE. You are by informed that the inquiry into the charges framed against you in connection with department proceedings were drawn against you has been completed. A copy of the inquiry report is enclosed. On perusal of the inquiry report, I find that charges of gross misconduct, indiscipline, and dereliction of duty framed against you has been proved. You are given 15 days time to make representation, if any. Further, you have to submit a written writing in within 15 days from that, whether you use for a personal hearing before the final order is passed.
Yes.
Thereafter, my lord, another so-called notice was issued by now by another authority, that is Assistant Inspector General of Police. There you are lost by page 58. That is on 12th of August 2021. After 6 months. That there is says, my lord, several times you have to submit your replies for where major punishments could not be inflicted upon you, you being absent from duty for so long and committed gross misconduct and dereliction of duty, which is proved in the department proceeding, and reply must reach within 7 days. Thereafter, I submitted my reply, my lord, on 12/8, my lord. And on 30th of November, the Assistant Inspector General of Police, my lord, administration, dismissed me from service.
When?
On 30th of November,
Okay.
page 60, my lord.
Dismissal.
Then I preferred an appeal before the Director General of Police.
Yes.
That is on 10/1/2022, my lord. 10/1/2021, my lord, actually. That is page 62, my lord. And the Director General, Assistant Inspector General, and communicate to me by order dated 30th. That on 7th of February 2022, my lord, my appeal was dismissed. Basically, my grievance is regarding this second so-called notice, because your lordship judgment is there in this regard, my lord.
Now, what is is that the ground? See, there is no requirement of a notice on the aspect of what penalty will be imposed.
Yes, sir.
Now, that is for the context that you cannot, as of right, ask that, no, I have not been given a notice for the penalty. Now that notice has been given, what prejudice have you suffered?
Because they have already decided, my lord, to impose a method.
No, it is the second shock has already been given. Your views have been taken. It is only on the aspect of the penalty.
Because your lordship judgment, in this case,
No, this judgment is not on that. The 42nd Amendment has said that there is no requirement to issue another notice on the aspect of penalty.
But here his notice was issued, my lord.
No, that will not vitiate the proceeding.
I
It is only
understand.
for the purpose that you cannot, as a matter of right, say that no, I have to be given a notice even for the penalty aspect. That is taken care of.
Yeah,
But
right.
if notice is given, no prejudice is caused to you.
Because now already they are determined to dismiss me from service.
That was after the procedure is done.
Yes, I understand, my lord. So, the letter may go back, my lord, decide afresh, my lord.
Why? What grounds?
Because your lordship, in similar judgment, your lordship has.
People also see page number 60.
What is the judgment here?
Here also your lordship has, here also a police personnel, my lord.
Yes,
Second,
that was not the second shock was notice was at the stage after furnishing the copy of the inquiry report and taking his views. Here that part is over.
yes,
Your
yes.
views have been taken, accepted. Now only on the question of penalty their notices.
No, your lordship has kindly, your lordship has. Yes,
No, we remember the judgment. It is
Yes,
not a
ma'am.
case where punishment or notice was given to you on the aspect of punishment.
yes, but here also my your lordship, authority by already, second no code, they have already decided to impose me a penalty. But
When has it come? Let us see that.
yeah, your lordship
Let
can.
us see.
Yes,
That page 58. Page 58. What is the stage of page 58?
Page 58, my lord, with reference to cited above, you have to submit your reply, response as why major penalties do not be imposed upon you. You be absent for restore continuous, which proof in the department process initiated
Which
against
is
you.
proved in the department process initiated you against you.
So-
And prior to this, the department proceedings inquiry report has been furnished to you, your views have been solicited, taken, considered, then this was not required.
That's why it's not required. They've already predetermined by themselves to impose them.
Predetermination, when is it come?
As why major penalties do not, they already determined, man.
See, what is the date of this?
That is on 12th August.
And what is the date of the forwarding of inquiry report? 17/3.
17/3 also, earlier also there, because there's another disciplinary, there's two disciplinary.
No, not at all. This is not due to disciplinary authorities.
Because
This is
one is
not
to find a
disciplinary.
police, my lord, that they are also,
This is not a ground.
there also the disciplinary authority has come to a finding that I find the charges of so and so as with because you are given treatment. But here, but that disciplinary authority did not decide the matter. He forwarded to another authority, the Lordship kindly. That was on 17/3/2021. Explained the SP was conducting the inquiry. He was a
See,
disciplinary.
the Assistant Inspector General of Police is above the rank of the SP.
I understand, my lord.
So
Now-
what is the fault? What is the legal flaw?
I understand, but there also they have decided to impose me a penalty, man.
Where?
Where in the second so-called note.
Page 50.
Page 58, man. Here, subject matter is also written as a so-called notice.
58 is of 12th of August 2021. You
Yes.
were given a report of the inquiry officer in March 2021.
Yeah, I understand, my lord.
Thereafter, they can simply pass an order of punishment.
Yes,
That cannot be a ground of challenge. You can have other grounds of challenge. There's a different aspect. You are not urging any other grounds of challenge.
basically on other grounds, my reports, my medical reports were never taken into consideration.
You were absent for 5 years in a disciplined force.
And in fact, your lordship judgment, my lord, very clear, my lord, that in case where a discipline authority has come, issues a second so-called notice, this is not permissible in law after 42nd amendment. So they are
It's
also
not permissible. It's not permissible. It's not required in the 40.
not required, my lord. There your lordship paragraph my
So
judgment
that
is-
is not, if it is done, will it vitiate the proceeding?
yes. So it was done in this case, my lord.
Will it vitiate the proceeding?
Proceeding might go back to the disciplinary authority, my lord.
Sorry. It is to be understood in the context that as a matter of right, you cannot ask for a notice of that nature.
I understand.
If it is done, it's you get an additional opportunity, even for the aspect of punishment.
That part, this matter may be remanded for conduct on this ground, my lord. Because-
Lordship will just have a glance at page
We'll
number.
come back.
Your lordship, I kindly see by then paragraph 8, my lord, of the judgment, my lord.
Yes. Now, that judgment is not in the context of a notice which has been given after furnishing of the report. Here, report of the inquiry officer given to you, your views taken, thereafter this notice is given.
The case which I have cited, there also, my lord, a department proceeding was initiated, my lord, so-called notice was issued, my lord, the copy was forwarded, but thereafter, my lord, in while the second so-called notice, there your lordship has declared that a bare perusal of the paragraph 7, bare perusal second notice disclosed that even before the second court was disciplinary already come to a conclusion. They have accepted findings of inquiry. So-called notice was disclosed the opportunity was given why major penalties do not impose upon him.
Here, this notice which you are challenging, 12/8/2021, is after consideration of your report, of your views on the report.
No, my view was not there at that
Your
point.
views were taken on 17/3/21. If you do not
17
furnish your report, that's your problem. Page 57.
No, my view was, I did not submit any reply, my lord,
That is your wish.
but
You may not,
Be-
you may not choose to give your report views.
because the matter went back to the another authority, that is the Inspector General at that point of time. So there are different authorities, and in fact, your lordship has come to a finding, my lord. There where your lordship has categorically stated that
11:3. 7 to 3:11, 3:11,
that the earlier disciplinary superintendent of police has come to a guilt, finding of guilt. Proceeding decided to continue with de novo, same would be done by another officer equivalent. That already when the disciplinary authority has come to a finding of guilt, that before posing a penalty,
Let us see your pleadings. Where have you stated? In the context of which notice?
that your lordship will find.
Your only ground is paragraph 14.
The paragraph 12, my stated matter. In
Well,
instant,
What have you stated?
that instant case, the disciplinary discipline of police initially so-called notice, but deprived of prisoner on unexpected disciplinary decided to go ahead with trial process. For an inquiry officer submitted inquiry report, a copy of the state order was communicated by later. Therefore, respondent claiming to be a disciplinary authority issued a second so-called. And the prisoner submitted a reply onto it. And by the dismissal, the respondent assumed the jurisdiction of on basis of note 4 appended to the schedule part Roman 12 of the Rule 60 or some penal empowers the State Inspector General of Police to exercise powers of penal police throughout the state. This initial so-called notice issued by respondent, which is lower in rank. That there we have said that it was lower in rank.
Who's lower in rank?
That earlier,
Superintendent. If
Yes.
a higher authority exists,
Higher-
what is the illegality?
then you will also may kindly connect. The State Inspector General has assumed jurisdiction.
No.
Then paragraph
We
14.
cannot, 14 only assails 12/8/2021.
Illegal second notice has been dispensed. Therefore, issuance of second notice dispensed by respondent was violative of Article 11(2) and Rule 66. Then he was then your lordship paragraph 15, my lord. He
Yes.
was predetermined to impose a penalty of dismissal from service by before issuing the dismissal law. The procedure that has been adopted by respondent of suffers for biasness, them being arbitrary and therefore
Who is
imposition of
respondent number 4? Is it the SP or the additional
assistant general inspector.
STM?
So they was predetermined because had they been they simply forwarded matter is there itself, my lord. So why they have to decide themselves that major penalty should not be
Mr.
imposed?
Kotoki, your submission would have been relevant if you are contending on the aspect when the second show cause notice as it stands was issued to you. You are arguing on the aspect of the further notice of 17.
Then earlier notice also they have stated that
Earlier notice you have said nothing. Where is
Yes.
your pleadings? That is why we are asking you the pleadings. You have said nothing.
no, there also they have come to a
Show us. Show us anything that you are agreed by the earlier notice.
I find that charges going to framing.
Show us where is your pleadings that it is not permissible. You have structured your entire writ petition on the notice of 12/8/2021, which is after furnishing you the copy of the inquiry report.
Because actually they did not act upon of the said notice. The lordship may kindly see. The earlier notice issued by the respondent, but the SP, the authority did not act upon the state notice. They rather the State Inspector General assumed jurisdiction by and
It's not
thereafter.
a question of assuming jurisdiction. It is a continuation of the departmental proceeding which was initiated on in the year 2019.
Yeah, I understand.
3/1/2019. It is not another departmental proceeding, not another inquiry.
But-
It is only passing of the final orders.
But,
And he is an officer above the rank of
I
SP.
understand, my lord, but the proceeding was initiated by a policeman. And so my humble submission, my lord, when it was already predetermined, my
If there was a error of jurisdiction that a person without authority whose rank is below the rank of SP, then matter would have been different.
But that we have already stated that he has, because State Inspector General jurisdiction all over Assam. That part is there. That
You have not said anything about 17/3/2021.
73, my lord, that was already overlapped because then when he has acted upon, my lord, this.
After 17/3, your views were called. If you have not submitted your views, it is your volition. We cannot say anything. Whether you submit or not submit, an opportunity needs to be given. It was given to you. Thereafter, he gives a further notice. It was not necessary, but he gives you.
But
You get a
that,
further chance.
but that the party authority already had determined, my lord, By the time I have that, they will impose the penalty.
There is no requirement of giving the notice. He could have straight away passed the order of penalty.
But that was not done, man. That is the
No, how are you suffering?
because
What prejudice?
they were already predetermined to.
No, if suppose we set aside this notice,
Yeah.
then also the punishment order cannot be set aside.
No, but they may look into it by
Sorry.
a minor penalty maybe in 2000, but that is up to them, my lord.
5 years you are out of the.
But that also was not taken into.
What is your reason? What reason?
That I have stated in my so-called notice, my lord.
What-
Reply,
what-
my lord.
what-
Your
what-
my kindly speak.
What reason?
That actually,
What happened to you? 5 years?
my wife was suffering from various diseases, my.
What disease?
That
Did you inform the authorities?
yes, I informed the authority time to time, my lord.
When, by what, which document? What document?
So medical certificates were not enclosed here, my lord.
Then what else?
Huh?
5 years.
That
You
That-
chose to remain at home, then suddenly you
that
go
your lordship can kindly see the certificates we have enclosed. Your lordship will find
page
page 24 onward.
24. What certificate? Let us see.
Medical certificate
Backache.
has
Your backache.
then there his father was suffered, my lord.
Now this is not father, this is you.
Yes, my lord. Then my wife, my lord. Your lordship, page 28, my lord.
28/6 is you again.
Page 28, page 27, 28, my lord.
Chest pain.
Lakshmi Sharma, my lord. The
28, Lakshmi
wife
Sharma.
of so. There was suffering with pregnancy and
Pregnant.
and
Is pregnancy an ailment?
no, she was suffering from bleeding, man. And there was miscarriage, man.
That will go for 5 years.
Then again, the second time also there was some bleeding, my lord, in 2014.
Will it
my
go for 5 years? This is of 2014.
Then his father also expired due to cancer, my lord. He was taken to Vellore for treatment, my lord.
Father expired when?
That was expired in 2015.
Yes. When was father expired in 26/11/2000? What?
It was expired, my lord, on
30/10/2014.
30th 2014.
What did you do till 18?
Then
18. What
Then-
did you do to 18?
then his brother also expired, my lord.
Oh my God. Then your neighbor expired.
No, my
There has to be a limit, Mr. Kotoki.
that
You
they
cannot
2000
just stretch like this.
2015, my lord, he expired, my lord.
Then 15 to 19, let us accept everything.
Then your lordship will find other
What
Doc-
documents? Now no documents.
the documents are there, my lord. Your
Okay, show us.
there,
We have checked all the documents.
that medical certificates are there. Those things were never taken into consideration.
This last medical certificate is of May 2017. Let us assume everything is correct.
Yes, my lord. Because meantime he joined, my lord, for some days, my lord.
Joined when?
There was a gap, my lord.
Your unauthorized absence from 13 to 18.
2018, my lord, he had joined, my lord.
That is 18, and this is last certificate is of May 2017. You have abandoned your service now, suddenly you want to come back.
So those things, so I pray, my lord, that the matter go back, let the body decide, my lord. Afresh.
Unauthorized absence from 5/11/2013 to 8/10/2018, to be very precise.
5-1.
5/1/2013. Yes, anything, Mr. Hazarika?
Just your lordship, Annex 12. He has admitted the charges, your lordship, in any case. Page
Page
59. In my, it is 60 by 59, in your lordship. Annex 12.
I accept the charges against me.
Here.
Right. The case of extreme case of hardship, my lordship, I consider. There was some personal
It's a
problem.
discipline force. You
I
are
understood
absent
everything,
for
my
5 years.
But still, you're also,
For your absence, many things can happen.
I understand. But considering at least he may be demoted, whatever it is, but the humility of authority considered all these aspects, my lord. Let the matter be remanded back to the disciplinary authority to decide. That's phrase, my.
Yes. Heard.
Only on that ground, my lord.
Sri P. Kotoki, learned counsel for the petitioner who has put to, no, petitioner also heard Sri C. S. Hazarika, learned state counsel, appearing for all the respondents. Please have your seat. Para. The subject matter of challenge in this petition is an order of dismissal from service of the petitioner as sub-inspector of police, which has also been affirmed by the appellate authority wide order dated 7/2/2022. पहले का order date में है, order of dismissal dated 30/11/2021. जो dismissal 30/11 होगा, appellate authority होगा 7/2/2022. What's the para? The facts as projected. No. Bereft of details, comma, the necessary facts as projected are as follows. The petitioner who was serving as a sub-inspector of police in the Assam police was served with a show cause notice dated 3/1/2019 on the allegation of unauthorized absence for the period 5/1/2013 to 8/10/2018. Full stop. The petitioner had submitted his reply on 3/1/2019 itself, whereafter wide communication dated 5/1/2019, comma, the enquiry officer and the presenting officer were appointed and the appointed, full stop. Thereafter, comma, the enquiry was held and the charges against the petitioner was found to be established, full stop. The report of the enquiry officer was forwarded to the petitioner by the disciplinary authority on 17/3/2021, asking for his views, full stop. It appears that, no, it is however the case of the petitioner that he did not submit any response, and thereafter on 12/8/2021 another notice was served upon him by the Assistant Inspector General of Police, within bracket ADMN, comma, Assam, whereby the response of the petitioner was sought for as to why a major penalty should not be inflicted upon him, full stop. The same was followed by the impugned order of dismissal from service dated, the said notice was responded to by the petitioner on 12/8/2021, full stop. Para. Thereafter, comma, why the impugned order dated 30/11/2021, comma, a major penalty of dismissal from service was imposed upon the petitioner, and the period of unauthorized absence was treated to be dias non, full stop. The petitioner had preferred a departmental appeal against the aforesaid order, which however was also rejected by the appellate authority. Wide order dated 7/2/2022. Full stop. Para. Sri Kotoki, the learned counsel for the petitioner, has submitted that the procedure suffers from legal infirmity as the notice dated 12/8/2021 issued by the Assistant Inspector General of Police, whereby already indicates that the said authority had come to a decision to inflict major penalty, and therefore there was no scope for the petitioner to file any effective response. Full stop. The learned counsel has also taken the ground that there was a change in the disciplinary authority as the initiation was done by the concerned superintendent of police, and subsequently the show cause notice dated 12/8/2021 was issued by the assistant IGP. Full stop. On the first ground, the learned counsel, by drawing the attention, and has submitted that there is no requirement to issue a second show cause notice on the aspect of penalty, which has been clarified by the 42nd Amendment of the Constitution of India. Full stop. In this connection, reliance has been placed upon the case of Muhammad Noor versus State of Assam, decided by this court in WPC 8318 of 2018, wide order dated 5/1/2022. Full stop. Para. On the merits of the allegation, the learned counsel has submitted that there were cogent reasons for not being for being absent, which included the ill health of the petitioner, his wife, and the death of his father after suffering from ailment. Full stop. Para. The learned counsel accordingly submits that the impugned orders are liable to be set aside. Full stop. Para. Per contra, Sri Hazarika, the learned state counsel, has submitted that the basis on which the writ petition has been structured is fallacious. Full stop. He submits that the notice dated 12/8/2021, though is on the aspect of the punishment, is after furnishing the copy of the inquiry report to the petitioner to seek his views. Full stop. The State Council, however, concedes that that after the 42nd Amendment of the Constitution of India, there is actually no requirement of such notice, which will otherwise not vitiate the proceeding as a whole, full stop. Para, the Learned Council has also drawn the attention of this court to the response of the petitioner dated 12/8/2021, wherein the petitioner has admitted the charges, full stop. It is further submitted that the services of the petitioner is in a discipline force and the charge public allegations are serious in nature, and therefore the penalty also cannot be held to be disproportionate, full stop. Para, the rival contentions and materials placed before this, full stop. Para, close scrutiny of the pleadings in the writ petition and from the arguments advanced, it transpires that the sole basis of making the present challenge is the show cause notice dated 12/8/2021, full stop. It appears that the grounds as projected is that the disciplinary authority had already come to a conclusion of inflicting a major penalty before taking the views of the delinquent petitioner, full stop. The aspect of the change in disciplinary authority has also been raised in the petition, full stop. Para, the notice dated 12/8/2021, no doubt discloses the intention of the disciplinary authority to impose a major penalty, is however not the second show cause notice as understood in the parlance of a disciplinary proceeding, full stop. In fact, this court has noticed that wide forwarding letter dated 17/3/2021, the inquiry report was already furnished to the petitioner, and in essence, the aforesaid notice dated 17/3/2021 is the second show cause notice, full stop. A second show cause notice which the petitioner chose not to respond to, full stop. Therefore, there was actually no requirement to issue another notice on the aspect of penalty, which has also been done away by the 42nd Amendment of the Constitution of India, full stop. However, issuance of such notice would not vitiate the proceeding, and the only objective of such amendment is that a delinquent cannot ask as a matter of right regarding a show cause notice on the aspect of imposition of a major penalty after completion of the inquiry and taking the views of the delinquent on such inquiry report, full stop. Para, the charge against the petitioner is unauthorized absence full stop. The period involved is more than 5 years, full stop. This court, in the interest of justice, has also examined the causes tried to be shown and the documents, full stop, full stop. None of the documents would even persuade this court to come to a conclusion that there were sufficient and cogent reasons for the petitioner not to preventing him from attending his duties, full stop. Most of the medical certificate are of the initial period, whereas the absence continued till October 2018, which started from 5/1/2013, full stop, para. This court has also the learned state council has also highlighted the aspect of admission of the allegation by the petitioner, full stop, para. The services of the petitioner as sub-inspector of police is in a discipline force and unauthorized absence for a period of 5 years, which has been held to be established in the disciplinary in the inquiry, will not lead this court to come to a conclusion that there is any requirement to interfere with the penalty of dismissal, full stop. The Writ Petition Act is accordingly found to be devoid of merits and is accordingly dismissed. The facts of the case of Muhammad Noor Supra, which has been relied upon, is distinguishable, as in that case, interference was made by this court, as in the second so-called notice itself, the disciplinary authority had come to a conclusion of inflicting a major penalty. Okay.
Okay.
Yes.
May I please, Your Lordship?
Yes.
Lordship, here we are required to file our.
Yes, Mr. Roy, he was seeking some
Yes,
adjournment.
my lord, I am appearing for the private respondent of,
Okay.
if like to file affidavit in reply against
government.
Okay, you file it.
2 weeks time may be given.
On the prayer of Sri A. Gayan, learned counsel for the petitioner, matter is adjourned by 3 weeks to enable filing of rejoinder affidavit to the affidavit of the
respondent of.
state respondents. Full stop. Have you filed affidavit?
No, my,
The further pleadings may also be exchanged in the meantime.
Much obliged, my.
First, I'm appearing.
Okay.
I've not filed further.
Okay. You'll file affidavit.
In contempt, we haven't filed, Lord. If necessary, we have
These
to
are all
file.
connected,
So, Your Lordship, main writ petition is the main,
but these are all with.
with Your Lordship, this is basically an offshoot. Item number 16 is an offshoot of the interim violation of the interim order. Your
Okay,
Lordship,
you have violated with interim order.
interim order. Because I have annexed
Not
the
purely,
specific details also.
Not purely.
What was the interim order?
Interim order was not to proceed with the disciplinary
Pass
procedure.
the order in
Not to
Have you
proceed with
passed?
it. No, we haven't passed. They have proceeded with that. They have called me, asked us.
Now, what was
statements.
what is the language expression used in the interim order?
Not to pass. Your Lordship,
to
if your Lordship takes up the contempt petition number 48 of item number 6. But your Lordship, if I may, take your Lordship's indulgence in the main writ petition. This is basically an offshoot of the earlier order passed by your Lordship, which fell from your Lordship in that particular writ petition.
Just a minute, please. Considering the may submit its respondent, however, no further order be passed in the
Till the return.
no further order.
No further order, your Lordship. Thereafter, your Lordship,
Have they passed any order?
they have called me up to give the statement. They have appointed presenting officer also. And preliminary hearing was conducted. If your Lordship goes to page number 15,
Doesn't matter.
your Lordship. But nonetheless, I'm not pressing for that much on in this particular contempt petition. I'm on the main.
If the matter would have been that they had gone ahead with passing in some orders which are against you, now it's on the stage of the inquiry only. We do not think that it may amount to contempt. They could have in their own wisdom held it as it's up to them. They want to go ahead, they can, but if they pass an order, matters will be different.
Very well, your Lordship.
And if you want to go ahead with the main writ petition, we can.
Yes.
Writ petition, you are prepared with the writ petition?
Readings are complete.
What is the matter?
Basically, if your Lordship, if I may take your Lordship to judgment.
Now, what is the main matter?
Main matter, your Lordship. Main matter, if the WPC number 6.
What is the issue? Just in
Here,
brief.
your Lordship, if I have to state it briefly, the petitioner, he applied for a particular post of LDC in the ICR. And then it was routed to proportional, and thereafter it was rejected. Then I approached your Lordship. The Lordship by judgment order dated 10/10/2023, which fell from your Lordship in WPC number 563, which is that allowed the writ petition and directed the respondent to give the NOC and just allow him to join. After that, instead of complying with the judgment, what they did, they issued a show cause notice. The memorandum of charges were issued, and wherein they charged me with the same issue which was decided by your Lordship, saying that you did not follow the proper channel and you applied directly, which has already been decided. I'll take your Lordship that particular case. And thereafter, they issued this memorandum of charge. That is under charge. That particular memorandum. If I have to state concise. Otherwise, if I have to take your Lordship.
Yes, why have you gone ahead?
But you have issued an NOC.
Huh?
NOC has been issued to it. On one occasion, they have issued the NOC. On the other hand, they are issuing the memorandum of charges.
Now, why memorandum of charges?
Lordship, whether we are precluded from going into the truth.
On that issue.
Lordship,
On that issue. For other issues, yes, you're open. On an issue which has been decided by the court, why?
Lordship, because the inquiry has to be conducted, because how is
Now, if you have issued the NOC, you're admitting, then where is the issue to be
no, that has
Level
been
and allegation.
decided because the ICR themselves speak that he has sent a blank envelope. So how he can be appointed after 4 years from the date of advertisement, Lord? It's a settled issue, your Lordship. If I may take your Lordship to the judgment itself. Whose fault was that? There may be, he may not be fault. Some of the other officers may be fault. Whether we are precluded to go into the departmental proceedings.
no,
to know
against
the truth.
him? You
Lordship.
make an inquiry, but why against the allegation against him? You inquire into the matter, blank envelope, who is at fault?
Lordship, he is because he is one of the prime party to that, Lord.
Let
was-
us
That was
let
under
us see the
contempt.
earlier order.
Yes, at
What
page
was-
number 60.
60.
It starts at page number 60. The Lordship, then I may take your Lordship to the operative portion at paragraph number 14, page 65.
60. $45. Paragraph?
65, page, para 14. In the instant case, if I may just read out.
Yes.
In the
It was
instant,
forwarded. Forwarding was in a blank envelope.
Yes,
No,
that
no,
is what the ICR has.
No,
stated.
no, no.
For the forwarding?
Yes, Lordship, page
That was-
Lordship, his own writ petition, Lordship.
No, was the forwarding done by him?
ICR stated that they have received a blank envelope, Lordship,
From whom?
for his application, Lordship.
From whom?
From them. And that is reflected in the
Page,
order.
page 51, Lordship,
51?
of the writ petition.
Yes. This picture.
Lordship, in this case, let the ICR come and say the what happened, Lordship. They can say only that.
Not required, they are not a party.
You have made him a party.
But the fact is, Your Lordship, this was already decided. If I may just read the judgment from the first page itself. Then. Because everything is reflected in the judgment and order.
Post.
Lordship, he applied after more than 2 months, Lordship.
Now, where is this letter of 10/10/2018?
That was applied to me on 14th of July 2022.
Where?
Your Lordship may kindly come to page number 49.
Yes.
Further to this, this letter dated 14th of July 2022. Further to this unit letter dated so and so was forwarded to this unit, copy of the following letters enclosed herewith. ICR letter dated 16/10/2018. And this 10/10/2018 letter is, I have annexed it. They are at, it is at page number 37. Everything was taken into consideration by Your Lordship. Everything. Now they're trying to reopen an issue which has already attained finality, and they have issued NOC to that regard for me to join.
Yes, Mr.
If I may take Your Lordship to the
Page
judgment.
37.
Lordship, the case is that he could not have sent the his application directly to the
Oh, what
ICR.
is this? This is your letter.
Lordship. And it was letter on withdrawal, Lordship.
No, 37.
Yes, Lordship, it was letter on withdrawal before.
No, recall means what? It was issued at one point of time.
Because under the policy, Lordship, guideline, Lordship, that will Lordship will find that page.
That part of recalling we had taken care of in the earlier judgment.
The earlier impugn order is at page number 54. Which was quashed by a doctor.
Lordship at page 105 of our affidavit,
105.
105, under the heading processing of application. F,
Yes.
point number AB. Application received from individual will be processed as per seniority based on date of receipt of application at.
We are not on the procedures.
Lordship,
We are asking a simple question. This 10/10/2018 is your letter.
rightly or wrongly, your Lordship has allowed his writ petition, he has to go. Now, we have issued the NOC, but the vigilance clearance that is pending because of the departmental proceeding has been initiated against, and that was not after the passing of the judgment. That was initiated prior to that in 2022. Not after passing of the judgment.
Your Lordship, this is purely an incorrect statement, Your Lordship. It was after passing of the judgment. I have annexed that particular.
Where is the, how do
memorandum
you
of charges.
substantiate that statement, Mr. Chakraborty?
122.
122.
122.
Yes. What is this?
This is a statement taken in 2022 itself. Lord.
Preliminary inquiry.
And
What
on the
is the
basis,
date?
on the basis of this, Lord,
What is the date? And there is no admission. He has simply said that he has sent it. What is the date of this?
for exact date, I have to take clarification from the
This is your paper.
department. Yes, Lord. From the office of,
Okay, we'll just have this some other day. We'll
yes, Lord.
apply some mind.
Okay.
I think matter is very serious.
Your Lordship, now what they have done, Your Lordship, they are contemplating another disciplinary action against me because Your Lordship directed me to join as a LDC in the ICR. After that, although they have issued the NOC, now and in the meantime, I became eligible for promotion to the post of UDC. Now I don't want to be promoted. I just want to go leave the organization and go to ICR. Meanwhile, what they have done, they have stated that if I do not accept if I have given my unwillingness also to get promoted. Now they are saying that if I do not, since I am giving my unwillingness, now I am liable to face disciplinary for giving up my promotion, as per one DOPT sir.
Let them take the action. If we cannot preempt them.
That's
Somebody wants to do some illegality
Yes,
at their own peril, let them do.
yes.
They know the consequence, what will happen.
Just that I'm raising the issue of urgency here also. So urgency.
Are you taking this personally, Mr.
No, no,
Chakraborty?
no. Not-
Ask your officers. It's not.
Because there is some serious flaws in
No,
his file.
there may be, but it doesn't appear. You could
He
have.
applied after
You could have
about 60
tested the order in the
He
division
applied
bench.
after about 60 days. Nothing happened in 4 years. After in 22, he has been appointed.
No, you cannot reopen the book. It has been closed. You can reopen before
In
some
the meantime,
other
he,
forum.
He came and joined here anticipating promotion. Someone's channel has been blocked, Lordship.
I have given my unwillingness also. They may
He's not
promote-
willing to be promoted.
After all this has been happened,
No. Can you take action against somebody who is not willing to be promoted?
he came here first saying that he is willing to avail the
No, he wants to
promotion.
join ICAR. You have given NOC. Now, because of this, he cannot go.
Anyway, Lord.
No, matter is very serious. If what we are thinking turns out to be correct, then the consequence will not be good.
Sure.
We would like to have the decision-making authority straight in the court. On a serious note, let us understand what they think. Tell us when. Next Thursday. Next Thursday.
Ninth.
9th.
9th, Your Lordship, there is some personal difficulty on the 14th, Your Lordship. 16th.
Last week will be different.
Can it be on 7th, Your Lordship?
17th.
7th. I'm sorry, Your Lordship, 8th or 45th.
8th we can try. 8th is a motion day, whether
Motion
we'll
day,
have
that is
time
the
to.
difficulty.
16th. Try on 16th.
Because they are actually harassing me day in and day out.
Tell us the date of your convenience. Huh?
14th, Your Lordship.
14th is okay for you? 14th?
Your Lordship, his presence is not required, Your Lordship. He's just there in the
Okay,
contempt.
you're for whom? Contempt
Contempt.
petition, we are not very, we are on the other side. Okay. As agreed to by the land council for the parties, list for admission hearing on 14/5.
The disciplinary authority is the commander, for this,
Interim order passed earlier to continue till the next date of listing. Yes.
Ms. Anuja Sood, she has been made a contender. He is actually going ahead with this whole disciplinary. Even though the DGPR has actually issued an, she is just a commander who has actually.
Now, that we will not modify that. That is only for the final orders. Okay. You advise your client to hold on. If he is unsuccessful, then you go ahead.
Hello.
Okay, next.
Lordship, before I proceed, Lordship may have a look to the orders dated 15/12 and 20/12/2023. Because this is a very serious thing. It is a hard-bound case. Even after finalized by division bench, and government can't prefer the any SLP also. Now, the pension is not yet released. 15/12 and 20/12. And they have given in the meantime lot of time.
Yes, what is this?
Yes, Your Lordship, on 20th of December 2023, Your Lordship, an copy of an instruction was placed, Your Lordship, whereby it was stated that the proposal has been moved to the Finance Department, wide file number such and such, for notionally fixing the petitioner's pay under FR 22 as sub-registrar with effect from the date of his joining on commission basis, till his regularization on notional basis as observed in para 7 of the judgment and order dated 12/5.
Yes, thereafter what has happened?
Your Lordship.
Thereafter what has
Thereafter,
happened?
Your Lordship, this matter has been placed before the Honorable Cabinet, Your Lordship, through a cabinet memorandum. Because it comprises of a huge financial implication.
And what
Your
has happened
Lordship.
thereafter?
Yes, Your Lordship. So, Lordship, I would ask for 2 weeks' time, Your Lordship, to place the updated.
Contempt of which year?
Contempt of 2015.
But then we were.
Then again,
impleted-
a personal appearance, Lordship.
Lordship, we were impleted very recently, Your Lordship, the revenue, respondent number 6. I'm for respondent number 6, Your Lordship.
Instead of 3 months, they shot 4 months, more than 4 months were given. And today this is the reply.
It's under process, Your Lordship.
Under process, it was dated in December
No,
also.
not together, Mr. Islam. Just sit down. Which order, madam? You are impleted?
Yes, this is Your Lordship.
You are appearing for whom?
I'm for respondent 6, yes. This is
Name.
order dated 31/7.
Respondent 6 name?
6 is DD Tripathi,
Okay.
Principal Secretary, Government of Assam, Revenue Department.
Okay.
DD Tripathi. This is order dated 31st of July 2023.
Okay. Thereafter,
Yes.
July 23 to we are in
Yes.
what? April 2020, May 2024. Almost a year. What have you done till a year? Yes, where is the order in question, Mr. Islam?
The division bench order, already submitted. That is in the IA for implement. IA 1794. Division bench judgment is at page 10. Paragraph 21, Lordship. Very specific. Government even went up to effect court, so not entertained 25,000 cost was imposed. And after that, all this paragraph
Yes, I mean,
21.
The services rendered by him as sub-registrar on commission basis should be included in for purpose of what have you received till now?
I am getting nothing. not a single penny after my retirement. I retired in 2013 March. Writ petition started in the year 2011. So already more than a decade. So I will again pray before your lordship, stand taken by this honorable court on 15/12. Lordship, you may kindly have a look. If they are simply doing nothing and always a vague submission, then personal appearance again.
Weak submission, your lordship, this matter has been placed before the honorable cabinet.
But
Kindly have a look.
When was it placed?
they shot 3
When was it
months.
placed?
That copy is also me with. That copy is not enough to take.
This was in December.
Yes,
December,
your lordship.
yes, yes.
Thereafter it was placed and thereafter this honorable court had granted time, your lordship, and today the matter is fixed and it's listed, your lordship. I need 6 weeks time to furnish the updated instruction.
Lordship, government shot 3 months, court granted 4 months, more than 4 months. And after that, today, this is their reply.
Okay, we'll grant 2 weeks time. We'll fix a date.
Lordship,
But
Lordship.
we'll
Lordship, in the meantime,
we'll
they,
monitor this matter.
yes.
3 months, you had stated in December.
Now it is May.
It's almost more than 4 months.
Yes.
Okay. Part 3 R Islam Learned Counsel for the petitioner. Full stop. Petitioner who has complained that though the judgment is of the year 2013.
Yes, Lordship.
2013.
22/9/2014.
2022/9/2014.
Passed in WBC number 3551.
Till now, the petitioner, till now, no steps have been taken towards implementation of the same, which involves his pensionary benefits. Sarah, Ms. Anne Baudelaire, Learned Counsel, and appearing for the respondent number 6, has submitted that as per written instructions dated 18/12/2023, the matter was to be placed before the cabinet of the state, for which 3 months' time would be required for arriving at a decision. Full stop. Though more than 3 months, more than 4 months has elapsed, it appears that no action has been taken towards the compliance of the order in question. Full stop. The Learned Counsel for respondent prays for some more time to have the latest instructions. Full stop. Para. In the instructions of, in the interest of justice, and as an exceptional case, matter is adjourned, granting time to the Learned Counsel to obtain necessary instructions. Full stop. Para. List on
21. My lord, let it be a hearing day. Otherwise, court is to take action.
list on 20.
20. All right.
25.
25.
Full stop.
This is the last chance, Lordship. Otherwise, they will always take time. Last 1 year, they are taking time. Deeply obliged.
I'm obliged.
Lordship, after attending finality, this is not the way of dispensation of justice, what they are doing.
My lord, the matter relates to selection of my lord finance and accounts officer and treasury officer. In substance, my lord, our allegation is some of the private respondents who were selected, they were actually, my lord, over it. Now, Lordship would recollect, or Lordship knows that there is a circular of Government of Assam dated 27/3/8. Now, initially, Assam Public Service Commission said, we cannot relax the age, therefore their cases cannot be considered.
Considered, okay.
In fact, their cases were rejected and returned.
Hmm.
Then, my lord, a fresh proposal came from the government, and that too a specific approval of the then Minister of Finance, State of Assam, in 2018, saying their cases has to be gone. Now this time, and my lord, the reason why the APSC did not consider their case was the judgment of Justice Ujjal Bhuya, my lord, where it said that there is a 309 OM of 1951 regarding age relaxation. So once the field is held by a 309 notification, 162 power cannot be invoked. So kindly see, my lord, that in our affidavit. Sorry.
Now what is the position?
Yes. Now the position is, my lord, we have challenged their appointment. Selection. Now, if your lordship could kindly come to page 51 of the additional affidavit in opposition filed on behalf of APSC, my lord. That in fact brings out our case.
Who is for APSC, Mr. Doctor? And for the state? Who's for the state? Private respondent. Who's for finance department? Finance is the party. Finance, madam, finance department. These are all hearing matters. We should give preference to these matters.
Yes, it's a 2019.
Yes, get the finance department. Otherwise, it's for hearing. We are not too much bothered whether pleadings are exchanged or not.
Yes.
We'll have it for disposal. If not today, then we'll fix a date.
Next week.
Next
or,
week.
or the week following next.
Whenever you say. But don't delay too much. 19 matters as early as possible.
Next week, next Tuesday is a holiday, my lord.
Thursday also we have fixed many matters. Don't have.
Following Tuesday, my lord.
Okay. Okay, we will try on 14th. Is it 14th?
14th.
Okay. Harshri K. and Chaudhary Lalit Senior Counsel for the petitioners in these cases, ESC, these cases, full stop. Though the private, the APSC, as well as the private respondent are represented by Sri P.P. Datta and Sri N. M. Alam, respectively, comma, there is no representation from the finance department, full stop para. In the interest of justice, list matter is adjourned to enable the concerned department to be represented, full stop. List on 14.5. Madam, 14.5, ask them to come. Finance department, 14.5. 14.5 will have, okay. No representation to the Regu side. I don't know. However, some accommodation is sought for on behalf of the finance department. No representation accordingly list on 14.5. Okay.
Right.
Okay. 21 to 23. 21 to 23, yes. Connected matters. Yes, Mr. Goswami. You are similarly placed.
Similarly.
And
Otherwise, factor all the same.
you are for higher education. What is the issue?
Issue, your lordship, the petitioners, your lordship, who were in two engineering colleges, your lordship. One is your lordship, Pinasar Brahmo Engineering College, and one is Rohtak Institute of Science and Technology. They were originally in the your lordship when their services were taken, your lordship. These two colleges were under society mode.
Okay.
Management was with a society, government society, your lordship. And then your lordship in 2016, the
this the management was taken over by the government.
Okay.
While doing so, your lordship, the government, your lordship, refixed their salary, your lordship, from 2016, your lordship. And the period of service they have rendered from 2009 to 2016, your lordship, that has completely given your lordship go by, your lordship. Now, as a result, your lordship, they have prejudicially affected. In the meanwhile, what they did, your lordship, in respect of another batch of teachers recruited in the year 2012, your lordship, and recruited
By the society.
no, in the society, but to the APS, your lordship, they were
But it was the society.
society under the
Management, you had said it taken
Lordship,
over in 16
they will
only.
come under the society. Your lordship.
Okay, okay.
Now, in respect of them, your lordship, the pay protection and the other seniority, etc., is not seniority, your lordship. The service period, previous service period should now counted, your lordship, but not in respect of us, your lordship.
How did you enter into service?
By your lordship, advertisement and selection.
Not by the APS.
Not by the APS.
But by an advertisement and selection.
Now they say that since they have been recruited by the APSC, but if that means, your lordship, control is always with the government, your lordship. And if that be the case, your lordship,
And your appointment in the college, was it approved by the authorities of the government?
every appointment, your lordship, ultimately the posts were sanctioned by the government.
No, the approval of the appointment.
Approval, the rule says, your lordship, that every appointment will have to be approved by the government, your lordship.
Government or the director?
No, your lordship, it says government. Your
It was regularized subsequently, 2008.
No, we are not on the regularization process. The initial induction into the service of the petitioners,
Yes,
was it finally approved by the department?
it was subsequently, not, it was approved from 2016 when the government has taken over the.
No, initial appointment, how was it done?
It was done by the society. By selection board was constituted by the society. Then they were appointed. Then subsequently in 2016.
Now, suppose in a deficit grant in a college, which is called a non-government college nowadays, any appointments made has to be finally approved by the director. Do you have any such?
No, your lordship, that is not there.
Okay.
That is not there.
And the selection committee was constituted by whom?
By the, your lordship, the
Who-
society, your lordship,
No, who were the, how was it, what was the constitution like? Who were the members?
it was, your lordship, constituted by the society. The advertisement was issued by the director in the name of society, your lordship.
Director of?
Director of higher education.
Okay,
Technical
and the selection committee constituted of whom?
By them, your lord.
By?
By the director itself, your lordship, on behalf of the
No,
society.
not constituting. Who constituted? Who are the members?
Members, your lordship, members, your lordship, that is not there with us, your lordship. Who are the members?
No, just to have an idea
Lord.
how they control over in the selection
Lord,
process.
Lord.
What's the, how, yes, please.
Lordship, that the constitution of selection committee, your lordship,
Okay.
it's a governing body approved the selection committee for the recruitment of faculty and ministerial staff institute as follows.
Hmm.
The selection committee is the additional chief secretary, education department chairman, vice chancellor of any university member, the director of technical education member secretary, one retired principal of any.
Okay, enough.
That. These are the, your lordship.
And who are you? Private respondent? Yes,
For the college.
college. Okay, there is no private respondent.
No,
You're-
no private.
Okay. Oh. Mr. Goswami, what is your similar, same college?
Same, but I have enclosed the memorandum of this from the society so that I can demonstrate how the society, although the name is society, but it is a society formed by the God. And initially, this was the Surhat Science College.
No, what, maybe we have not come to the conclusion, but your claim is not for the period when you work for the society. Your claim starts when your college was taken over by the government
Lord.
and giving you proper fitment and a pay protection. That much only.
That much, your lord.
And giving the benefit of the seniority from the initial.
From the 2000.
Had it been that you want higher pay for the earlier period, then matter would have been different.
Lord.
That is not your case.
We want, your lordship, that continuity. your lordship.
Continuity, number one, pay protection
Pay
at the time of when the matter was taken, the colleges were taken by the
Lord.
government. And
And the hours, previous service period should be counted for
All purpose of seniority.
seniority and your lordship for caste, your lordship. Essentially, your lordship, there is no other promotion except your lordship under career advancement scheme. Your lordship. Virtually,
Yes.
Our sense is that government has taken over the 13th, 14th. From the appointment order itself, it is clear that they were initially temporarily engaged and the salary, pay scale, etc. were governed by the society regulations. Lordship may come to the.
No, that is the initial appointment.
Yes,
See,
initial appointment.
they cannot be, see, a job seeker cannot have the power to choose.
Yes, sir.
Whatever he's offered, he takes.
Yes.
Now, it so happens that the management is taken over from the society by the government.
Sure.
Initial entry was by a proper procedure. We are trying to emphasize on that.
Yes.
And it was, the selection committee was headed by all government officials in your department as well as concerned functionaries of the government.
But they were the chairman, etc. were constituted by the governing body of the society. Does not matter.
Yes, doesn't matter. But who were the persons
Yes.
who had done the selection, who had conducted the selection? Selection is not questioned by anybody. Their induction in the service is not questioned by anybody. You are not, it's not the case that initially they were put into ad hoc, then regularized or something. They had entered in by a proper process. Now, can you deny the benefit which they would accrue from their, from the stint they had discharged the duties under the society?
But their selection cannot be weighted with the APS selecting and with the.
APSC is a commission through which it is done.
As for lordship,
There are many appointments still made not by the APSC. There, as of now, you have a recruitment commission.
Yes.
Can you say that no, it's not, cannot
But at
equate with?
that time-
There are certain categories which APSC does.
Yes.
There are certain other categories, depending on the nature of the job.
At that time, APS were the body which.
No, APSC would not make a recruitment for a college run by a society.
Yes.
So that was, it's not that the APSC was the selection was to be done by APSC, but still it was not done. It is not the case. It could not have been done. Do you think it is fair?
But subsequently, only their services were figured out. Right in 2018, with effect from 2016. But that date when the colleges were taken over by.
And the initial period?
Initial period, they were given the pay and allowances as admissible as per the rules of the society. It is there.
But at their induction, at the time of induction in the
yes, in
the college, after taking over by the government, was pay protection given to them? Then
one national increment was given.
pay protection.
so far as other group is concerned, they have given your lordship. Now, in spite of the fact that they have come under, they have come much later than us in the college, your lordship, in 2012. They were getting all the benefit, and your lordship, if it is controlled by the society, how come your lordship government make a
How are those members getting? What was the difference?
difference, your lordship? Now they are getting more than us. your
No,
lordship.
no. What was the difference in the initial entry?
Because your lordship initial entry is that APS is selected and government made appointments.
No, no. For the 12.
12,
They were done by APSC.
APS is selection and government appointed. Now,
But it was still a society.
still a society, your lordship. Now, even the recruitment, lordship.
Yes, if you, can we do it today?
My lord, it's to defer the hearing. My lord, keep it part.
Not part of, we can have it on any other day.
Day after tomorrow.
Day after Saturday will not come. You may come.
No. Next Tuesday, my lord.
Next Tuesday
Next
also
Tuesday
you may
also
come, will not come. We'll go for voting. This is not Jorhat, Mr. Goswami. Or we should say Juhat. Not Jorhat, it's
Nice.
Juhat.
Yes, my
Yes. Mr. Borua is also endorsing. How do you pronounce Jorhat?
Jorhat.
You don't say Jorhat. Anyone from Jorhat will say Juhat. There is no raw.
I don't know.
We are from Sipsagar, Guru and on 9th.
Okay.
Your Lordship.
9th, we have fixed many matters, but still then we can try.
Lord.
This will not take much time.
No,
Let's
will
fix
not.
on 9th.
Lord, hi.
9th.
Hearing paper.
9th बहुत mentoress.
Yes.
9th बहुत mentoress. 8th kuri juni. Yeah, let's try on 8th.
Lord, 8th.
9th, we have fixed many matters.
8th. Your Lordship.
Prepare a small synopsis, note kind of. Okay. Okay.
Oblige.
This is for hearing. No? As agreed to by the learned counsel for the parties, list for hearing on 8/5/2024.
Deeply.
The petition will not come at that because seniority is given. Then so if the person appointed by the petitioner take care of regarding because they were not want to
Let us
on
see
that
the
on
respect.
that.
At least the pay protection part and their fitment. And if there is a continuity, if tomorrow after their retirement, they will at least get the benefit of their service.
My lord, another news, use this scheme, my lord, there is no scope for any seniority or promotion, my lord. It's only career as first.
Yes.
Okay. আৰু আছে নেকি কিবা এই মোৰ কিবা হেৰি মণিপুৰ ৰিপৰ্টটো কৰিব আছে তিনিটা কি আছে মেটাৰ দুটা আছে What are these matters 24 25
So even 24 is there for reckoning that retrospective seniority lordship. Petitioner was selected earlier.
49 batch and 58 batch. He was selected in the 58 batch. But he
ought
wants
to have been
seniority from the
selected
49 batch because of some correction in the earlier seniority.
of which what post
for sub-inspector lordship. I appeared in 49 batch lordship, but I could not be selected. Later on, as per the High Court order, it was redone. In the redone select list, my name appeared. But in the meantime, I got again selected in 49 batch in a phase interview lordship, and I was working for 10 years. Now, 2017, they have published a read-on list, and I have applied that keep seniority to that read-on list, corrected list, but they have
we'll
refused.
have to hear some
They have been asked to
we'll
provide
have some other day Wednesday okay
lordship.
and 25 to Wednesday as agreed to by the
24.
council on Wednesday and 25 what is the matter Mr. Rafiq
What is the punishment of dismissal from practice?
what service
He was a constable.
constable
Constable.
what are your grounds of challenge
Selective punishment. Selective punishment.
selected punishment means
Well, the charges are there are charges against 3 persons. Only I was awarded the punishment of.
no if the charges are found to be proved against you can you is the aspect of discrimination available in punishment
Yes. I have to judgment also getting that.
no are the charges against the other persons of
Identical.
proved
Well,
proved or not charged may be identical
against me it is proof.
against them
Against them they have been let of with a lesser punishment.
what is the lesser
One
punishment
increment I think.
and your
Dismissal.
what do you do constable
Constable.
others are also the constable
One is SI and another one is also constable.
yes Mr. Hazarika what do you say
Lordship, here it is going, there was an order for records. That's not there right now, Your Lord.
you get the records 22 matter but we'll have to decide so he's out of job
Yes.
when was the order of penalty
And so,
22 or 21
21.
21 okay
31, 12, 20.
okay otherwise affidavit has been filed
Yes.
do pleadings have been exchanged comma Sri C.S. Hazarika, London State Council submits that the records of the disciplinary proceeding would be required, may be required in the adjudication process. Full stop. He accordingly prays for and is granted 2 weeks time to obtain the records.
Yes.
Full stop. Please for hearing there
Yes,
after 2 weeks.
the record of the other person matter.
That is one DP, I think.
No, separate DP.
Separate. The records of the DP for the other 2 personnel
Yes.
may also be procured.
Yes.
Other 2 personnel may also be procured. You give it to him.
Yes.
Yes, next.
27 appeals.
But matter is partly hard on 34 post of time to the fix. The penalty imposed the petitioner one increment with cumulative effect. That cumulative effect has not prescribed in the rules and acts of the Assam Police Manual. Only increment has been prescribed. And on this regard, this honorable court passed order whereby
It is done under, not under 64 rules.
no mal. It is under defeat drawn against Assam Police Manual, Assam Police Section.
Yes, what do you say, Mr. Hazarika?
He's not separate. He's coming here. That's my petitioner who was a constable and subsequently promoted to ASI and entrusted him to see the pension matters of the under the commandant. And thereafter defeat drawn against the petitioner prior to initiation of the DP the explanation was called finally page 17.
That is your sole ground.
Sole ground.
That punishment which is not prescribed by the rules cannot be inflicted. One increment with cumulative effect.
Right.
Mr. Hazarika, you remove the cumulative effect. What was the misconduct?
Misconduct allegation is that I have prepared the leave unleave account counter leave account to 300 days though the returned person only 94 days avail unleave. But there is no false prima facie, it is a long calculation of the leave account. Not the false of the service record. And in my written statement, I also stated due to the release of the debt amount, the government may recover the excess money from the GPF amount of that person, and subsequently that amount also recovered from that person. Therefore, no money lost by the government from the lost.
But your grounds are not on this point.
Point paragraph number 17. 17
Yes.
On perusal of the impugned order dated 21/12/2018, it appears that disciplinary authority neither adhered the reasons for explain the fact on which he had arrived such decision. Moreover, penalty imposed upon the petitioner is not prescribed under the relevant rules and act. some.
That was in 1819. You remove the cumulative effect, he gets back everything. Matter ends there. Mr. Nath? He's harping on mainly on one point. The penalty is not prescribed by the rules. Cumulative part.
It is perfect. No, only increment, withholding of increment. Affidavit of opposition filed by the respondent number 7, my lord. My lord, he is silent about that matter. Ground.
Only on that point. We may not go into the other aspects.
Yes,
If you remove the
Sir.
cumulative, and in fact, these are penalties of 1819. 1819. If you remove the cumulative effect, it will otherwise also have no relevance on his part. Only cumulative makes it a permanent denial.
Well, kindly see, this is a disciplinary proceeding and the 64 Act, there are some
Rules.
rules. 64 rules, it applies.
Where is it? Cumulative.
Well, kindly come to withholding of increment of.
Yes.
Well, this is a minor penalty. It has already the honorable court in a decision, well, just this. It is Lordship has already held that this is a minor penalty. There is a decision, it is Bipin Chandra Thakuria, it is reported in 1997, 1 DLJ 90. But I have been.
No, what is it? What has been laid down?
Here, Lordship has held that this withholding of increment with one increment with cumulative effect, it is a minor penalty and it is under the rules of penalty.
No, that has to be in consonance with the rules. Rules are before us. That decision may be par incurriam the statute. It shows in the statute. He's making a very simple point. If the penalty is not prescribed in the statute, you cannot.
But withholding of kindly similar this withholding of increments of promotion. This is under rule 3,
Only the cumulative part. We are not on the withholding part.
Well, FR 24 is very clear.
Yes.
FR 24 says that an increment shall ordinarily be drawn as a matter of course unless it is withheld. An increment may be withheld from a government servant by the state government or by any authority to whom the state government may delegate this power under Rule 6 if his conduct has not been good or his work has not been satisfactory. In ordering the withholding of an increment, the withholding authority shall state the period for which it is withheld and whether the postponement shall have effect of postponing future increment. So what would be the increment? What would be the effect of the withholding of increment? The authority, while passing the order, has to clarify that. Similar, when the rule prescribes that withholding of increment is a penalty, what would be the effect with cumulative effect or without cumulative effect? It has to be stated. It has to be stated by the authority while passing the order. Rule 24 of FR 24 is there, and this decision along with another decision of the
FR 54.
FR 24. FR 24.
But 24 is not in connect. Is not a punishment.
24.
This withholding of increment is in the context of a penalty which has culminated from a DP.
But
Here, the withholding of increment is in the context in FR 24 as a normal course of, ordinary course of discharge of duties.
Well,
You can withhold increment when he has not been good with his work or work has not been satisfactory.
correct.
It is not a consequence of a DP.
My respectful submission. The the source of power for withholding of increment, but it comes from this.
No, no,
I'll-
no,
I'll
no.
take-
Source of power is not this.
No.
This FR is, this FR 24 is only in connection with discharge of duties. What you can do, what you cannot do.
Look,
The
that
here,
is- that
if
is
you,
what-
if
that
you
is what
come to
Lord-
1964 rules,
That is what, my lord, yes,
the penalties have been prescribed.
yes,
If you come to the penalties prescribed,
yes,
you do not find any such penalty of where you can withhold increments on a cumulative effect. It has a connotation, cumulative effect, not giving cumulative effect, giving cumulative effect. If you're not give, it's only for a temporary period, he gets back everything after the period is over.
yes,
So if it's cumulative forever, it's lost.
whatever it is, yes. But so the withholding of increment is a punishment prescribed in the rule.
Yes, you withhold.
And but withholding of increment, that has to be that ultimately if whether it is with cumulative or without cumulative, that has to be said, that has to be specified by the authority at the time of passing of the order. That is the rule 24 it prescribes. FR 24.
FR 24, is it in the context of penalty?
In any case, whether when the authority is ultimately not satisfied with the service of the petitioner, ultimately in this departmental proceeding, what the charge is the dereliction of duty and misconduct on the part of the petitioner. But finally, he has failed to
No,
discharge his duties to the
see,
satisfaction.
here, it is very, conditions are already specified in 24.
An
If
incremental,
his conduct has not been good
Lord,
or his work has not been satisfactory,
yes, Lord.
here it's a different matter altogether that in discharge of his duties, he is found to be indulging in certain misconduct.
Lord, it is
You hold an
relating-
inquiry.
it is relating to his conduct only. His conduct has been proved in this DP that he has not properly discharged his duty. Well, in one case,
Yes.
there is an issue raised by the petitioner that punishment of withholding of increment has been imposed on the petitioner, but he has been denied protection. Ultimately, while discussing that, the lordship has, the honorable court has clarified that what is stoppage of increment, what would be the effect. Ultimately, in this particular writ petition, it goes against the authority because there was some difficulty. But while discussing, the honorable court has clarified that. But I'll take your lordship.
No, we'll have it some other day. This is the point we'll definitely ponder.
I'll definitely try to.
There
satisfy your
is, as you have pointed out,
Lord.
there is also an element of his conduct not being good.
Definitely, my
Whether
lord.
this bad conduct or not good conduct can be directly related with a proceeding for misconduct.
Yes, ma'am. It is a conduct on the part of the petitioner. That is
In the FR, where are the provisions regarding proceedings DP? Mr. Padgiri, have a look in this.
as per the decision of 2019, that 2019 CLR, that decision, there specifically in CRP rule this provision is there. And ultimately, para 14-16 also lordship 32 days unauthorized leave that was not commensurate, that punishment not come. That is not a different
Okay, we'll try to. Consider.
my
Okay.
respectful submission to that is
Okay, we'll
that's
have
not
it some other
applicable
day.
here.
We'll
But-
have some
but-
other day.
Look, effort from at various points, from dismissal, removal, compulsory term, or whatever punishment
although departmental proceeding is not specifically here, it is stated here, but at various places, those things are started. I'll take your logic to. So, my lord, my submission would be the punishment imposed is as regard the conduct of the petitioner, and it is not, it is, although they have said that the alternatively, my submission would be, they said that withholding of increment, it is not, they have no problem. But if it is, the problem is with only the cumulative effect, means the punishment is little harsh. That is what they want to say. In that case, the argument of the petitioner is that the punishment is not proportionate or disproportionate. That would be ultimately the argument by the petitioner. But the
No,
proportion,
with that disproportionate part is a different aspect.
that is altogether a different
The
aspect.
different aspect will, but if he can convince us
Sir.
that it is not even a penalty prescribed, the cumulative part,
Sir.
then we'll not go into the aspect of disproportionate or being proportionate. What is the gravity of the offense? Those part we may not go because
Otherwise,
as we have indicated, holding back of increment simpliciter is only a temporary for a temporary kind of a measure for a particular period. He gets back everything. It's not a permanent denial. So as on today, it will not have any bearing. It's of 1819. But if it's cumulative, he loses.
for that it goes forever.
Yes, forever. So that is only part.
Sir.
Your disproportionate we may not go into. If we are satisfied that no, you have the power
Yes.
to
We have.
impose such a penalty,
Yes.
and then we perhaps then he may be still be have the opportunity to convince on the disproportionate proportionally part, but that will be a very the scope will be very less because it made emphasis on the
True, man.
okay
True.
paucity of time
Sir.
did not allow the matter to be taken up for hearing to the full stop. The issue involves a penalty in a disciplinary proceeding of withholding of increment with cumulative effect. Full stop. The principal contention of the petitioner is that such penalty is not prescribed in the statute holding the field. Full stop. In this connection, the Assam Disciplinary Appeal Rules of 1964 as well as the Assam Police Manual have been pressed into service. Full stop. Para. Sri D. Nath, the learned senior government advocate, Assam, has, however, refuted the aforesaid contention by taking recourse to FR 24, as per which it is up to the employer state to indicate as to how and what effect should be given to an action of withholding of increments. Full stop. Para. The aforesaid aspects would be considered. List. When? List. 15th of May? Is it okay? 15 May.
First, item number 25. First, after you put the records, the petitioner said that there are two other persons are recorded
Yes,
pending your
yes.
But right now I had a talk and he said that only one DP has been completed, another DP has not been completed. So that will only delay the proceeding if your lordship asks for the record of the uncompleted DP. So if you produce the
You have
record of-
instructions on that whatever you are saying, bring it on instructions that there is no completion, so there is no record.